defective matters are being taken up as
After final disposal, it is listed. Therefore, in 2 weeks once it has the final case is listed, it has not been able to take up. If 415 also your lordships can take up the.
नहीं file दी जाएगी. Give it to me right now. Serial number?
It's 12 minutes. I just.
Like file line.
I just put it in.
Item 12.
File is coming. Just pay.
Yes, what is it?
The file is coming. So just pay for sure. The small limitation is.
Name of the defendant
Yes,
number 3 is differing from the name of.
Yes, we have filed the fresh Vakalapnama as well as your lordships had directed last occasion that I may file an IA for ignoring that defect. So only that IA is.
What is the difference between the two?
It's now
Appealant number 5. Who is appealant number 5?
5 is Ansari. But we have now filed a fresh Vakalapnama also as per the office order. The Vakalapnama is on record. The right name.
What was the name in the trial court? Is it an error in the order or it's an error in the party name in the.
In the Vakalapnama?
No. It is an error in the party name in the dealings between the parties.
No, it's just a mistake by the applicant in the Vakalapnama. He signed the different name. Because he had that name also, so he signed that. Now he has filed a fresh Vakalapnama with the name of another side. As depicted in the appeal ordinance.
Okay. First appeal number 126 of 2024 with IA number
Number 1183 of 25.
1183 of 2025. There is a defect in connection with the name of the appealant number 5. In order to consider the interlocutory application and the defect and prayer for ignoring the defect, this court is of the view that the records of the learned court is required to be called for. Let the records of the court be called for from the concerned court. Post this case on uh, 30th of April. Let this order be communicated through this.
From daily list, under heading for final disposal, item 3, second April 1 to 7 of 2019.
My senior is on Lex in court number 17 is coming in 2 minutes.
I'm praying for the 2 weeks of adjournment as the senior counsel, Mr. Rajesh Pandey, is ill today and he cannot attend the court.
You have not circulated advance notice for it.
Worship, he has been very ill on Saturday, that's why I have not given the I.
So, there is no advance notice for adjournment. We will not adjourn the cases like that. Even if a person is ill, he can certainly give an adjournment notice. Inform the court master. इसका क्या मतलब है? पिछली बार तो अपीलेंट आई ही नहीं. The hearing has commenced. He has not come to the court.
No, Worship, he is ill.
क्या होगा?
Fever हो गया Worship, 102 fever.
कब चाहिए?
Worship, अपने 2 week का बात करो.
2 वीक तक फीवर में रहेंगे.
Worship, 1 week.
It's a parted matter.
1 week का.
अब इनको फीवर हो गया तो क्या करेंगे?
पर्सनल है तो आप कुछ नहीं बोल सकते. फर्स्ट टाइम
एडवांस नोटिस देने के लिए आपको किसने मना किया था? खड़े हो गए हैं आप बताइए. रिकॉर्ड तो खुद पढ़ते नहीं है। पिछली बार भी आपके वकील साहब नहीं पढ़ के आए थे, इसीलिए टाइम हुआ था। सारा बर्डन कोर्ट पर है रिकॉर्ड पढ़ने का, और एडवांस नोटिस भी नहीं देते। और आपके पर्सनल ग्राउंड में एडजर्न नहीं करे तो आप लोग स्ट्राइक कर देते हैं कि पर्सनल ग्राउंड है हमारा। सही है। और उसके बाद 2 हफ्ता का टाइम मांगते हैं, एज इफ 2 हफ्ता तक आएंगे नहीं वो कोर्ट। Pertinent questions है, पूरा argument recorded, and your counsel was absolutely clueless on the last date, absolutely clueless. Secretary number 127 of 2019. Learned counsel for the appellant is present. नाम बताइए अपना।
Karan Pandey.
Mr. Karan Pandey, advocate, submits that the arguing counsel Mr. Radheshyam Pandey is not well and he has not come to the court. कोई appearance में उनको दिखना नहीं चाहिए किसी केस में उनका appearance, as he is suffering from fever. He submits that the matter be posted next week. Post on next Wednesday. नाइन को ही तो
16 को
भूल जाए हम तब तक। भाई 9 अब बताइए, ये तो आप हमको बता दीजिए कब करेंगे। 9 आपको परेशानी है, आप कब करेंगे? ऐसा नहीं होता, कोई चीज ना इस तरह से पार्टनर करके नहीं छोड़ सकते। आप लोग की तरह मैं भी ठीक है 7 ठीक है, नेक्स्ट वीक आप बोले ना, नेक्स्ट वीक 7 से शुरू हो रहा है। हाँ एक सेकेंड, the judgment is will be pronounced in the second half. आपका फर्स्ट अपील में मेरा जजमेंट कंप्लीट नहीं है, ठीक है। आई एम पोस्टिंग इट ऑन 9th, ओके। तो जस्ट आई जो सेकंड वाला फर्स्ट अपील है उसमें लिखिए लेट दिस मैटर बी पोस्टेड ऑन 9th अंडर द सेम। कुछ रह गया ऐसे बिना सेटिस्फाइड में नहीं, और जजमेंट प्रोनाउंस करने के बाद सेम डे अपलोड करना एज अ प्रिंसिपल आई थिंक दैट शुड बी डन। और सेकेंड अपील वाला जो है वो प्रोनाउंस हो।
Item 4 WPC 4007 of 2020.
Only passport few cases. Only few cases.
दोनों साइड एक साथ आएंगे तभी होगा।
Item 5 SA 149 of 2023.
The applicant has filed an IS introducing additional evidence.
Who has filed it? Apply. So what do you want?
Madam, since the argument already commenced, madam, it is not an appropriate stage, madam.
File number 4092 of 2025, and there is a supplementary affidavit bearing on record the order of acquittal from the court below and the notice.
When was he acquitted?
He was
2023.
2023 leadership on 11/5/2023.
After the disposal of the trial court judgment.
Madam,
But it has been mentioned in the trial court judgment that he was granted bail, anticipatory bail in this matter, and thereafter he has been acquitted. The case was filed against the appellant.
आपको क्या बोलना है? ये सब चीज क्या है?
madam, it will be of no use, madam, since the property stood already sold prior to the execution of the
आप
purpose.
किस लिए आप परेशान हैं इसमें?
But it is
अगर फाइल किया है तो we will consider criminal case में acquittal का क्या ही relevance होगा?
apart one more document has been.
Which document has
Legal
been
notice,
legal
legal notice.
That was
Legal notice we will not.
That was the legal notice.
There is no supporting pleading in the plaint as well, madam. Para 14 of the plaint deals with the sending of registered notice, no statement as to the service.
आप इसका एक response file कर दीजिए formally. Okay? How much time do you need?
10 days time, my lord. The client has to confirm that.
देखिए जो एडिशनल एविडेंस फर्स्ट अपील में आता है ना उसको कंसिडर तो करना ही होता है भले हम रिजेक्ट करें चाहे अलाउ करें यू कैन देयर इज नो एक्सप्लेनेशन वो सारी चीजें अपनी जगह है लेकिन एक बार आ गया है इफ यू वांट टू डिस्प्यूट इट इफ यू वांट टू से एनीथिंग बिकॉज यहाँ तो फिर डिपोजिशन होगा नहीं कोई एग्जिबिट नहीं होगा एज सच सो यू नीड टू रिस्पॉन्ड विद दिस
And in the IE also there is no specific pleading
अपना
establishing
जो
that
भी आपको रिस्पॉन्स यू आर वेल अवेयर अब अभी उस केस में भी आप एडिशनल एविडेंस आप ही प्लेस किए हैं तो फर्स्ट अपील कौन सा यहाँ पे फर्स्ट अपील है जो बिना एडिशनल एविडेंस के डिसाइड हुआ
And that matter was remanded leadership on the ground of additional evidence itself.
रिमांड नहीं होने वाला है आपको पहले ही बता दिए इसका क्या फ्यूचर
No, no.
एफए नंबर 149 ऑफ 2023 supplementary affidavit
Because IA, if it is disposed of in supplementary affidavit, I have brought the documents, and in the IA, I have preferred that these documents may be taken as the additional evidence.
इसका ओरिजिनल कहाँ है एनेक्शन 2 का
ओरिजिनल तो इनको भेज दिए, मेरे पास तो उसकी कॉपी ही थी.
receipt तो original है. Postal receipt.
पोस्टल रिसीट ओरिजिनल कहाँ
यही है जो डॉक्यूमेंट में है. This is
देखिए एडिशनल एविडेंस में ओरिजिनल डॉक्यूमेंट्स प्रोड्यूस करना पड़ता है इनसे भी करवाएं इन्होंने अपने रिकॉर्ड में 15 डॉक्यूमेंट्स लगाए थे और जितना ओरिजिनल प्रोड्यूस किया है उतना ही कंसीडर होगा वेयर इज इट वेयर इज ओरिजिनल
This is the document.
Even date
And
does not-
I have stated in my this that
कि
there is
पोस्टल
a
रिसीट भी साथ में भेज दिए
नहीं, there is a specific averment that it was sent to him, and we have stated in our IA that though it was submitted before the court below file, but it was never marked as an exhibit. So I never thereafter I do not have the possession of the original.
ओरिजिनल ऑफ व्हाट
Even the receipt or the notice was already sent to him. I had a copy, and I have taken a plea that it was deposited in the court below, but due to inadvertence it was not marked as an exhibit.
व्हेन डिड यू डिपॉजिट आपको रिकॉर्ड से बताना पड़ेगा जो चीज रिकॉर्ड में नहीं है आपके कहने से तो नहीं चलेगा ना
नहीं उसका ये नहीं, पर वो पता करने पे because we have specifically taken it.
things which are not in the record either it should be there in the order sheet that you have filed it or it should be available in the records as received your statement will not suffice let's say how do you believe it what is the material to believe that you filed it and you have not exhibited it and this original of this postal receipt was also filed in the record
Everything was filed in the court below, but it was not marked as an exhibit.
My lord, the files must have been filed with list of documents.
yes
It is not there.
it is not there it is not available देखिए आइए कौन सा है
IE 4094
4092 of 2025.
आइए नंबर 4092 of 2025 This interlocutory application has been filed under Order 41 Rule 27 seeking to adduce additional evidence before this court. The documents which are sought to be adduced as additional evidence has been placed along with supplementary affidavit dated 28/3/2025. The two documents have been produced through the supplementary affidavit. One is certified copy of the judgment dated 11th of May 2023 passed in GR case number 1049 of 2008 and the other is photocopy of the legal notice dated 27/8/2007 along with photocopy of the postal receipt.
It has been wrongly stated as AD.
It has been pointed out the postal receipt इसमें date भी नहीं
Date with
which does not even
It has a total number, but it is not.
but the date of dispatch is not apparent from the same. Upon a query of this court, the learned counsel for the appellant has submitted that she is not in a position to produce the original of Annexure 2 as the same was dispatched and she does not even have a copy of the original of the postal receipt. And it has been stated in the petition seeking additional evidence that the same was filed in the court, but inadvertently it could not be marked as exhibit. The legal notice was filed in the court, but inadvertently it could not be marked as exhibit. आप AD के बारे में नहीं बोले हैं, it was filed in the court. But no such statement has been made in the interlocutory application that the AD or the postal receipt was also filed in the court, and the photocopy of the document which has been annexed along with the legal notice is not the AD.
And does not bear the seal of the postal department.
उतना नहीं बोलेंगे. However, the counsel for the respondents, एक है कि ज़्यादा है? Respondent prays for and is granted 10 days time to file a response to the interlocutory application as well as the supplementary affidavit. Let the needful be done by 11th of April. Post on 15th of April. एक बार रिकॉर्ड चेक कर लीजिए. ये है रिकॉर्ड, आप दोनों बैठे चेक कर लीजिए.
Item 6, FY 25 of 2024.
Yes, applicant. Who is for the applicant?
Yes, I am. Let's show on last occasion, this matter was just hearing has commenced. The question was what has to be procedure in case of ex parte procedure? Whether the issues are required to be framed or point of determination on what stage and their consequences. Thus there is judgment of conjugal effects to on this.
Where is the other side?
As validity, sir, they have not appeared. There is one idea for intervention that leadership has said that if I am allowing this appeal, then
Which paragraph?
page 370. Parasitic. But there is substance in other of this.
No, I'm just, you see, I'm just on the point when the proceeding is ex parte, how the matter is.
Yes, that is specifically dealt in that.
In para number 34,
If leadership would say, I will read the entire 33.
you read it, because I want to see that specifically.
Yes, yes.
Was this proceeding ex parte?
Yes, proceeding.
Let us see it from the first paragraph.
The present list, having attained the age of 15 years by that time, is now following tale of long delays consuming frustration in the mind of the suitor who deprived of his property. He must promptly to the court for indicating of his rights and seeking protection under the arms of law. He faced adjournment and adjournments looked that time is not necessary. As paragraph 3. Anil Palwani, the plaintiff respondent, hearing Palwani for short, have filed a suit styled for suit for
Where is it? Where are you reading? You have left a few lines.
paragraph 2.
Paragraph.
Yes, one is specific.
Yes.
Again, Panjwani, the plaintiff respondent, hereinafter Panjwani for short, filed a suit styled as a suit for declaration, position, and permanent injunction against Ramesh Chandra Arkwadiya, defendant appellant Arkwadiya in short. The plaint was presented on 9/2/1987 in the Court of Addition in Class 1, Jaipur City, West Jaipur. The suit property is plot number 2, area 273.03 square yards, described by the boundaries in para 3 of the plaint. Briefly stated, the gist of the plaint government is that on 1985, Panjwani entered into an agreement for purchase of the suit property for a consideration of rupees 4,500 from one Sri Nivas Vaidya, the then owner of the suit property. A document in writing was executed. Rupees 4,000 were paid.
This is about the plaint,
This is
the
about
proceeding.
plaint.
Then para 4 is, it was accompanied with order 39 Route 1 and 2
Yes.
petition. Then on the day it was presented, some advocate commissioner was
Yes.
appointed. Then on 10/2/87, the defendant appeared.
Yes,
Read this, para 7.
yes. On 10/2/1987, the defendant appeared in the court through his counsel. However, the presiding officer was on leave, though the defendant was served with summons in the suit, as also with notice on the prayer for grant of ad interim injunction. No written statement or reply was filed on 10/2/1987. The presiding officer was on leave on this day also. The matter was placed before a judge in charge. He directed status quo as to the suit property to be maintained, restraining the defendant not to proceed with any construction ahead. Thereafter, on 15 dates of hearing, the matter was simply adjourned without defendants having filed any written statement of reply. On 2/4/1987, the plaintiff used a second application for appointment of yet another commissioner to carry out inspection of the suit property in the presence of both parties. It appears that the purpose for appointment of second commissioner was to have the bipart inspection carried out, as the inspection carried out on 9/2/1987 by Sri Pratap Singh, Advocate Commissioner, was in the absence of the defendant, and there was some element of urgency involved in the inspection on that day, so as to bring on record of the court the status of the suit property and the date of institution of suit. Sri S.K. Kataria, advocate now appointed as Advocate Commissioner, carried out inspection of the suit property on 23/5/1987 in the presence of the plaintiff and a representative of the defendant, probably the special power of attorney holder. Sri Kataria also drew up a sketch of the suit plot incorporated in his report. The identity of the plot is the same, but with a little change as to its status. Building material consisting of brick, sand, stone was lying on the plot. In the northwest corner, instead of hut, a temporary kitchen of bare bricks had come up, and in the northeast corner, covering an area of 6 into 12 feet, two small rooms and platform had come up with which were newly constructed. The report drawn by the commissioner bears the signature of plaintiff and the representatives of the defendant here itself. We may observe that the second report by the advocate commissioner, the correctness whereof has not been disputed by the defendant at any stage of the proceeding, is prima facie suggestive of two inferences. Firstly, even till date, bipartite inspection carried out by the advocate commissioner, the plot was a vacant piece of land on which construction had just commenced and was in process of coming up. And secondly, the defendant has proceeded with construction work in spite of interim order of the court directing status quo as to the suit property to be maintained, and specifically restraining the defendant from proceeding with the construction ahead. On 4/6/1988, under administrative order of district judge, the case came to be transferred to the court of additional judge. Thereafter, it was adjourned for 29
It's
days.
a checkered history.
is a checkered history and the relevant consideration paragraph 3 is specific
Yes,
with
para number 14. You read para. Where is it that the judgment was passed without framing any issue, and where is it?
If very should
In
be
para
required with
30?
5 minutes time, para 33 deals
No,
with
we'll come to that. Para 14.
defendant preferred first appeal against the judgment and decree dated 8/1/2001, which was registered as FA number 3 of 2001. It was heard and dismissed by
Second
5th
appeal also
Additional
dismissed.
District Judge Jharkhand by judgment and decree dated 7/3/2001. Defendant preferred second appeal, which was dismissed in January on 16/4/2001 by the High Court, forming an opinion that appeal did not involve any substantial question of law within the meaning of Section 100 CPC. An application under Order 41/27 filed by the defendant before the first appellate court seeking production of certain document by way of additional evidence was rejected by the first appellate court, as in its opinion no case for admission of additional evidence was made of. The High Court found no fault with the view so taken by the learned additional sessions district judge. This SLP by the defendant has been filed on 28/4/2001. On 16/7/2001, the authoritative bench of this court directed notice in SLP to be issued on that day. Plaintiff Panjwani, who was present in person, having filed a caveat opposing the special leave petition, the court allowed him to file counter affidavit and order status quo as of date continue. The hearing of this hearing in this court has an unpleasant flavor, as there have been contempt proceedings drawn up as an offshoot of this appeal, and the case has been accepted for hearing amongst different benches. We have heard the relevant senior counsel for the petitioner and the respondent present in person, with the understanding that the appeals shall be heard and disposed of finally, in which they have agreed. The relevant senior counsel for the appellate has made several submissions.
See, 3 points were made.
Yes.
1 and 2 were point of jurisdiction and counterclaim.
Yes.
These two were rejected outside, out
Yes.
at the outset.
Yes.
The Honorable Supreme Court found that there was some merit so far as the last plea is concerned.
Yes.
That is,
even
if the proceeding is ex parte,
against the defendant,
the plaintiff was not entitled to a victory as plaintiff.
Yes.
Now, let us see the discussion from where it starts.
Para 30. No, sorry, 32.
Just a minute.
The third and the last
Just a
submission.
moment. The counterclaim was also rejected. There was no such.
Para 32 is the third and last submission.
32. Yes, the third and the last.
The third and the last submission of learned senior counsel for the appellate is that even if suit proceeds for hearing ex parte, the court is not absolved of its duty of deciding the case in accordance with law. Rather, an additional obligation is cast on the court to act with caution and be watchful to see that in the absence of any opponent, the plaintiff does not succeed in achieving what he is not entitled to or which he does not deserve, and that in no case he succeeds in overreaching the court. On 2 counts, the trial court has unwittingly fallen into error, submitted the learned senior counsel of the appellate. Firstly, that the plaintiff being entitled to further relief of specific performance of his suit for mere declaration of title, recovery of possession and injunction was not maintainable, and secondly, that on the averment made in the claim, the appropriate remedy of the plaintiff was to have filed a suit for specific performance of contract for sale in his favor, entered into by Sri Nivas Vaidya, and unless and until he had perfected his title by execution of sale deed, he could not have been declared the owner of the property. So far as the plea of power of maintainability of suit for failure to seek further relief is concerned, we cannot find fault with the plaint as framed. The defendant was alleged to be a rank trespasser who was in the process of committing a trespass and was allegedly raising unauthorized construction over the suit property neither owned nor legally possessed by him. The relief for specific performance is not a further relief to which the plaintiff is entitled or which he could have sought for against this defendant. Thus, from the point of view of the present defendant, we cannot find any such defect or infirmity in the relief sought for by the plaintiff as would render the suit not maintainable and liable to be thrown out at the threshold. But from here I would say, but there is substance in the other limb of this submission made by the learned senior counsel for the defendant appellate. Even if the suit proceeds ex parte and in absence of any written statement, unless the applicability of Order 8 Rule 10 is attracted and the court acts thereunder, the necessity of proof by the plaintiff of his case to the satisfaction of the court cannot be dispensed with. The absence of denial of the plaint averment, the burden of proof on which the plaintiff is not very heavy. So I am saying that also, that my burden, citing those judgments as if it is a contested that you failed to prove your bona fide, that cannot be. Burden is there, but it is not so heavy. In absence of denial of plaint, averment of the burden of the proof on the plaintiff is not very heavy. A prima facie proof of the relevant fact constituting the cause of action would suffice, and the court would grant the plaintiff such relief as to which he may in law be found entitled. In a case which has proceeded ex parte, the court is not bound to frame issues under Order 14 and deliver judgment on every issue as required by
So
Order
this,
20.
this argument is negative. You were arguing on that day that the issue was still
Yes,
valid.
yes,
This is
yes,
negative.
that is negative, and yet, my lords, yet the trial court should scrutinize the available pleading and documents, consider the evidence adduced, and would do well to frame the points of determination. That is also not done.
Point of determination has also not
Nothing.
been
Plain
made.
WS then says this judgment, this judgment, this judgment, and you are not in.
Further, kindly, I proceed to construct the
And proceed to construct the ex parte judgment dealing with the points at issue one by one.
that's
Merely because the defendant is absent, the court shall not admit evidence and admissibility whereof is excluded by law, not permitted its discussion being influenced by irrelevant or inadmissible. That means evidence has to be admissible. So,
admissible evidence has to be
we
there,
see,
irrespective of the fact whether there is a written statement or it is being opposed by the defendant.
yes, my evidences has to be an admissible evidence, not irrelevant. Number two, now the
Did
test
the-
one is prima facie.
Did the plaintiff examine any witness?
3 witnesses.
3 witnesses. Did he give any documentary evidence?
Yes,
How
my
many?
agreement.
How
There
many?
are, yes, I am sorry.
How many documentary evidences were produced? Let's have a look at the judgment.
Yes. Start from page 16 of the memo.
What was the suit for? You just turn one by one. We turn the pages one by one. It was for title suit?
This is a suit for specific performance of contract by me, I am the plaintiff, and the sole defendant.
You are the sole defendant. Right.
I am the plaintiff, my suit is dismissed.
Or your suit is dismissed.
It's an ex parte, suit is dismissed.
So your contention is that you are the plaintiff, the suit is dismissed. Your contention is that the suit ought to have been allowed.
The suit ought to have been allowed, or the trial court at least have framed the point of determination and should have given one by one finding on it. Number two, the
On the
test.
basis of evidences, whatever was
Yes,
adduced.
and the test, the error committed by the trial court is that it has applied those redress based on need, which prima facie is not required because the other side is not there. The court has to see prima facie I have made out my case. It's not that what would happen if they have said that there is no readiness and willingness.
So
then-
therefore, in a case, in first appeal, if the trial court has not done the needful, this court can do it. Kindly argue this. Your
But
problem.
even if
I have for the intervener without land owner, real land owner, and he has entered into agreement for sale of the land of one of the co-sharer as per allegation in the plaint. That he is the one of the co-owner and
Let us see, you are just the interviewer, right?
yes,
he is just the intervener who says that even my
I will-
seller doesn't have
I
title,
will
he
read
has got
my
the
law.
title over this property. So it is not a case that somebody attached to the defendant is coming for the protection. He says that even my vendor, would-be vendor, he has also got no title. He
So
is the actual
therefore,
owner.
under such circumstances, if your vendor has no title, then he is not bound by that sale deed.
Yes, therefore his
Simple.
presence is not required.
Therefore,
That-
third party rights are not going to be adjudicated in a specific performance of contract. If your
That is
vendor
right.
has no title, so whatever you do it at your own risk. If you pay the stamp duty for the execution of the sale deed, then therefore
And that will be not binding upon him.
that will not be binding upon him. You should
My
be happy with
submission,
that.
my submission is, that this is the case of a specific performance contract. The vendor has not appeared deliberately before the Lorette trial court, before this honorable court also, and they are living in same locality. My submission is that they are living in same locality both, vendor and the person who is claiming that he is obtain a agreement for
You
sale.
had filed your intervention application.
Before the Lorette trial court also,
Okay.
that was rejected.
That was
Thereafter, we have preferred CMP before this honorable court.
Okay.
During pendency of CMP, judgment has been passed, so we have withdrawn my CMP with and this application has been withdrawn. And the vendor, if has not appeared deliberately, then in this case, court has to direct the register the sale deed. In this case, specific performance contract.
That's right.
So this intervener is required to present before this court.
So therefore, if it is observed that the vendor does not have title, then it will not bind you. That should suffice your purpose.
Yes, my suffice.
That will suffice your purpose.
Purpose will suffice, but yes, my lord.
If your contention is that the vendor does not have the title,
Yes, my lord.
but still he wants to execute his specific performance of contract, so it is for him to, because court will not decide the title of the vendor.
Yes.
Court will only decide the specific
Yes.
performance of contract.
Yes.
Then under such circumstances, this should be sufficient to reject your application.
No.
This observation is more than sufficient to reject your application,
But
isn't
no.
it? That it will not be binding on you. You see, he will only get the title whatever the vendor has. He cannot have, the court also cannot pass a better title than what the vendor has. Correct?
Yes, my lord.
So that should suffice your purpose. Batai?
I will assist, my lord, after his argument, my lord.
After his argument.
But then what will remain
There is order, earlier order, my lord has passed the order earlier that he has to file counter affidavit upon my intervener application.
Have you filed your counter?
But till date, he has
You have not
not filed any counter affidavit. So I will assist upon
So
my.
I'm just
Ji.
asking.
Yes.
This observation should be sufficient. He will get his sale deed executed at his own peril.
But through the court, my lord.
So what? कोर्ट से करे चाहे वेंडर करे, इससे कोई फर्क पड़ता
The
थोड़ी.
court that is binding upon this.
इतना पोल्यूशन इनको करना होता तो वेंडर तो खुद ही जाके कर लेता ना. स्पेसिफिक परफॉर्मेंस क्यों होता? Right? We are not here to decide the title over the property. We are here to only decide the specific performance of contract.
Yes, but my submission, one thing also, title of vendor is required or not in suit for specific performance of contract.
कहाँ लिखा है? title decide करेगा court whether the vendor has
At least
title or
he has
not.
to show that he has a title or not. Uh, Suppose that I have no title of any this high court itself, and I have entered into a specific agreement for
That will
sale
not be
from
binding
the
on the
person.
that will
From
not
the
be
person.
binding that will not be binding on the High Court. If you give the
From
example of the High
person,
Court,
I have entered into agreement for
you
sale.
can enter into a number of agreements.
Then court has to see that whether he has a title or not. At least he has to satisfy the court that he has title and he has entered into
अब क्या पता कि आपको वेंडर ने सेटअप किया है या आपको इन्होंने सेटअप किया है.
सेटअप किया रहता है माइनर तब तो हम वहाँ पे पहुँच ही जाते हैं.
ये डायरेक्टली कंटेस्ट कर रहे हैं, नॉट असिस्टिंग.
नहीं, you just tell us. आप इसको लीगल पॉइंट बताइए. In a specific performance of contract, what are the basic ingredients one has to see?
Only the court has to see that whether the agreement for sale is genuine or not,
Yes.
and he is ready and willing to perform
His part of the
contract or not.
Yes. इतना ही देखना है
Yes.
ना. फिर अगर कोर्ट से कोई सेलिंग हो भी जाता है, पोजीशन किसके पास है?
Possession definitely this intervener.
आपके पास है.
Yes.
आप खुश रहिए. जब आपके पास एग्जीक्यूशन के लिए पोजीशन के लिए आएगा तो बोलिए इट इज नॉट बाइंडिंग ऑन मी. देन एट द टाइम ऑफ एग्जीक्यूशन देखिए अभी तो स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट में क्या चीज होगा? सिर्फ सेल डीड एग्जीक्यूट होगा. देयर कैन बी नो डायरेक्शन फॉर गिविंग पोजीशन. करेक्ट?
Yes.
नहीं होगा ना.
Yes.
पोजीशन के लिए उनको अलग सूट करना पड़ेगा. राइट? देन यू विल हैव अ राइट टू कंटेस्ट द सूट. आप क्यों यहाँ आकर अपना केस क्यों खराब करना चाहते हैं?
खराब नहीं.
आप आपको बता रहे हैं क्या क्या consequences possible है. We are just we are assuming that your case is genuine.
My property has been put in risk. So
you are worried.
So,
We will protect you. हाँ बताइए क्या क्या किया.
There are 3 witnesses and 4 exhibits.
Let us see the relief. To receive the balance consideration and execute the same deed.
May I to refer the plaintiff, sir?
ये पेज नंबर 18 में आइए ना आप अपना इंटरनल पेज 4.
The plaintiff prayed for the following relief: to adjudicate and direct the defendant to receive balance consideration amount and execute said deed in favor of the plaintiff of his 1/3 share in Schedule A. The defendant be restrained to sell the suit land by granting of injunction, the cost of suit and for a year.
So there is no prayer for recovery of possession ऐसा कुछ नहीं. ऐसा है भी नहीं ना होता भी नहीं है नॉर्मली. अच्छा आप बताइए आपका एग्रीमेंट ऑफ सेल कब का है?
Yes.
What is the date of agreement? Unregistered?
Yes, it is.
Agreement is dated
12/9/2018.
12/9.
2018.
What is the exhibit?
Exhibit 1. And the another submission myself shows. A date of agreement is 12/9/2018. He has refused me and I have filed suit on 5/2/2019. I am only saying for this that within 6 months from date of agreement I have filed. This is my bona fide.
Where is the agreement? Agreement.
Exhibit 1.
एक करारनामा.
Yes.
ठीक है. Timeline क्या है? What was the consideration amount and what is the timeline?
Consideration मूल्य third 6,28,571 per kattha for 2 acres 84 decimal, and the advance was paid 9 lakhs.
Total was 4 crore.
4 crores 46 lakh 28,500.
That was the total value.
Total value of entire.
Advance money is 9,000.
9 lakhs.
Okay, how did you pay it? What is the mode of payment?
That was paid in cash.
It is not mentioned in the agreement.
Agreement page 3.
Page 3 only.
Of this agreement itself, it is mentioned.
Nagad प्राप्त.
Yes, Nagad प्राप्त.
ठीक, okay. आगे जब संपूर्ण कागजात उपलब्ध हो जाएगा तो लेखाकारी के नाम से ये नाम
के नाम से या लेखाकारी जिनके नाम से कहेंगे मींस मी और
हाँ
आलविन से
yes
उनके नाम पे रजिस्टर्ड केवाला तामील कर देंगे। रजिस्टर्ड केवाला करने में आनाकानी करने पर लेखाकारी को अधिकार होगा कि बकाए रुपए अदालत में जमा कर अपने नाम से कंपल्सरी रजिस्ट्री करवा सकते हैं, या कि हम लेखाकारी यह भी इकरार करते हैं कि कोर्ट का जमीन हर वर्देन से पाक व साफ है। किसी तरह का वर्देन या नुक्स पाए जाने पे लेखाकारी कानूनन पायबंद होंगे, यह कि हम लेखाकारी उपरोक्त जमीन को किसी अन्य व्यक्ति के साथ एग्रीमेंट बिक्री आदि नहीं किए हैं, नहीं कर सकते हैं। अगर ऐसा पाया गया तो लेखाकारी कानूनन पायबंद होंगे, वो रहेंगे। इसलिए आस्थानिक सजा से। So this agreement was executed on 12/9/2018. It's not a case where I am sitting idle. My case is very simple.
yes इसमें कोई टाइमलाइन नहीं है
कोई टाइम नहीं, बट विदिन रिजनेबल टाइम होना चाहिए और इन्फिनिटी भी तो हो नहीं सकता।
नहीं तो इसका भी तो कुछ आपके पास होगा ना नॉर्मली ऐसे एग्रीमेंट्स में टाइमलाइन होता है
Suit for specific performance of contract, 3 days I will show. इसका कोई टाइमलाइन नहीं है। 12/9/2018 को एग्रीमेंट होता है। इसमें लिखा है कि कागज के बारे में कि जब संपूर्ण कागज उपलब्ध हो जाएगा तो leadership will only give me 5 minutes to show what is my case. 12/9/2018 agreement was entered. It is well written, reduced in writing कि जब कागज तैयार हो जाएगा तो करेंगे। Now exhibit 4 is order by which his name was entered in register 2. That is 31/1/2019.
एक सेकंड
Because his name was not there, succession mutation case was pending. That is exhibit 4. Which was ultimately allowed, and this order stands. Nobody has challenged it.
it was mutated in his name
In his mother's name. The property belongs to the maternal grandfather of that person. Khatyan is there. Uncles have got their name succeeded there. Mother was left. On behalf of his mother, he has filed an objection. That was allowed, and his name was also entered there. That I am sure. Those
along
are
with the mother
yes, yes.
so mother is also
मदर
a
का
party
डेथ
in
हो
this
चुका है, इसलिए उनका
कब डेथ हुआ mother what is the date of death
that is not there exactly
prior to agreement or post agreement
prior to it.
I don't know
That is also not there, but
so it is
as per
important
the
no because
order
you are
sheet,
relying
it
upon
appears
the
that she is not alive before the revenue authorities.
when is the order passed in the by the revenue
It was passed on 31st January 2019, and I have filed this suit on 5th of
did you
February.
need any evidence that on the date of agreement the mother was alive or dead
यहाँ पे लिखा हुआ है कि kindly come to page 1. The recital was there.
page 1
Page 1. संपत्ति रकबा मौती 8 एकड़ 52 डेसिबल जमीन हथियार रईती कायमी वकील मौजा सिक्का थाना हजारीबाग सच उपरोक्त खाता नंबर 6 की संपत्ति सर्वे सेटलमेंट में छेदी सौदागर पिता शेख निजाम के नाम से दर्ज पाया। बाद वाफत इंस्टेड छेदी सौदागर उनके पुत्र अब्दुल हफीज उपरोक्त संपत्ति पे कायम हुए व तहकीकात हुए अब्दुल हफीज की 2 पुत्री, एक पुत्र सुबरन मोहम्मद हनीफ मुन्नू प्रथम पक्ष की मां हुई। मोहम्मद हनीफ पिता के रहते ही स्वर्गवास कर गए। सुबरन एवं उनके एक पालक पुत्र लोटो मियां नावल्द स्वर्गवास कर गए हैं। लेखकारी उपरोक्त संपत्ति पे शांतिपूर्वक कायम काबिज व तकरार चलते आ रहे हैं।
कहाँ लिखा है कि दिस प्रथम पक्ष की माँ has expired? It is rather specifically not mentioned. They are saying who all have expired, but Ma has expired is not mentioned. So she was the owner of the property at that point of time, at least the co-owner.
But kindly come to Exhibit 4. Death certificate is filed before the revenue authorities. And Exhibit 4, internal page 9. That is mentioned. रजिस्ट्रार जन्म मृत्यु नगर पालिका परिषद मुगरसराय चंदौली उत्तर प्रदेश से आवेदक के माता के मृत्यु प्रमाण पत्र के सत्यापन का अवलोकन किया गया। इस the order sheet of additional collector. The first, second,
एडिशनल कलेक्टर के ऑर्डर शीट से नहीं चलेगा ना, आपके एविडेंस से चलेगा, डॉक्यूमेंट से नहीं चलेगा कि वहाँ पे क्या फाइल किया। आपने एविडेंस में बोला है that she had expired prior to the agreement. And what was the document in support of that?
death certificate is
Not there. So, at the time of entering into the agreement, she was not the party to the agreement. And even as per your case, the property belonged to her because it was devolving through her.
Section 17 of the specific performances clearly provide that the contract to sell or let property by one who has no title, not specifically enforced.
So therefore,
by the vendor.
I do not. Vendor का ही कहानी सुना रहे हैं.
हाँ, by that section 17 is for the
Actually
vendor.
ना उनका बात हमको सुनाइए. हम आपसे पूछ रहे हैं. Your vendor has given the description of the property and how the property is claiming, right? And according to you, it was the maternal property from the maternal side, Nana के side का property. Mother is also there in between, correct? And it is devolving to him through mother, right? Mother is alive on the date of the agreement.
That is no.
It is mentioned in the agreement itself.
Nothing is mentioned, therefore.
So therefore, in a suit for specific performance of contract, the court has to satisfy itself that if any agreement, if any deed is directed to be executed, then the person has proper title. You are talking about the mutation. You are saying that needful was to be done as per the mutation. The date of death of the mother is not there. And what happened in the mutation?
That was.
पढ़िए आप लगाए हैं document तो पढ़िए.
Exhibit 4. निष्कर्ष अगर second last पेज से देखेंगे उससे पहले cases है डेथ सर्टिफिकेट्स का वेरिफिकेशन है and निष्कर्ष अपीलार्थी आवेदक द्वारा संलग्न वंशावली के अनुसार छेदी सौदागर को एक पुत्र अब्दुल हनीफ एवं 2 पुत्रियां सुबरन एवं मुन्नू थी, किंतु मौजा सिरका खाता नंबर 6 की भूमि का उत्तराधिकारी नामांकन आवेदक की माता मुन्नू को छोड़ के किया है। प्रश्नगत भूमि की जांच के क्रम में अंचल अधिकारी द्वारा पाया गया कि प्रश्नगत भूमि में 2 मजार एवं एक बड़ा तालाब है जहां सालाना उसका आयोजन होता है। कुछ भाग में रैयत के वंशज निवास कर रहे हैं जबकि भूमि का कुछ भाग खाली एवं बढ़ती है। अंचल अधिकारी सदर हजारीबाग द्वारा आवेदक के संलग्न वंशावली के संबंध में पूछताछ किया तो उन्होंने वंशावली को गलत बताया एवं आवेदक को अपना वंश का अंश मानने से इनकार किया गया। अंचल अधिकारी द्वारा स्थानीय जांच किया गया एवं छेदी सौदागर के स्थानीय निवास के रह रहे वंशजों से पूछताछ किया। लाटू तालाब परिसर में निवास कर रहे छेदी सौदागर के वंशज पप्पू ने मोहम्मद शरीफ को छेदी सौदागर के वंशज मानने से इनकार किया। उनका कहना है कि मुन्नू छेदी सौदागर की पुत्री की नावद मृत्यु हो गई थी, मीन्स माय मदर हैज डाइड विदाउट एनी। जब इन्होंने मुन्नू का मृत्यु प्रमाण पत्र दिखाया गया जिसमें पति का नाम मोहम्मद इब्राहिम अंकित है, जो इनके द्वारा इस मृत्यु प्रमाण पत्र को जाली बताया गया एवं इसकी जांच की मांग की गई। एक पटिया मोहल्ले में निवास कर रहे छेदी नाव सौदागर के वंशजों मोहम्मद नियाज, मोहम्मद वसीम के द्वारा भी उपरोक्त तथ्यों का अनुमोदन किया गया तथा मोहम्मद शरीफ को अपने वंशावली में मानने से इनकार किया। पूछताछ से यह स्पष्ट हुआ कि इस संबंध में अंचल कार्यालय सदर में वाद संख्या 5 2012-13 निष्पादित हो चुका है। अपर न्यायाधीश सहायक स्तर न्यायाधीश अतिरिक्त सब्जेक्ट 3 हजारीबाग से आवेदक द्वारा टीए केस संख्या 5171 के सत्यापन के अनुरोध में ओसी टू एडिशनल सेशंस जज द्वारा निम्न रूप से प्रतिवेदन उपलब्ध कराया गया है, जिसमें प्रतिवेदन प्राप्त हुआ है कि आपका पत्रांक 2259 दिनांक 3/11/17 जो मेरे न्यायालय में डाक द्वारा आया था, इस वाद से संबंधित कोई कागजात मेरे न्यायालय में उपलब्ध नहीं है, ना ही मेरे न्यायालय से संबंधित है। ऑन दिस पेपर माय मदर वाज एक्सक्लूडेड एंड दे हैव गॉट देयर नेम इंक्लूडेड। तहसीलदार मुगल सराय चंदौली से आवेदक द्वारा उपलब्ध कराए गए पारिवारिक सूची के सत्यापन के आलोक में तहसीलदार मुगल सराय चंदौली द्वारा अपने कार्यालय पत्रांक 408 राली दिनांक 27/11/2017 द्वारा सत्यापन प्रतिवेदन उपलब्ध कराया गया। रजिस्टर जन्म मृत्यु नगर पालिका परिषद मुगलसराय चंदौली से उत्तर प्रदेश से आवेदक की माता के मृत्यु प्रमाण पत्र के सत्यापन के अवलोकन में प्रतिवेदन प्राप्त है। उत्तराधिकारी नामांतरण वाद 62-63 में खतियानी रैयत की पुत्री मुन्नी का नाम क्यों छोड़ा गया यह स्पष्ट नहीं है, जबकि सत्यापन प्रतिवेदन से प्रतीत होता है कि आवेदक की माता स्वर्गीय मुन्नी पति इब्राहिम पुत्री मोहम्मद हफीज है, जो उत्तराधिकारी होने का प्रमाणित करते हैं। साथ ही आवेदक मोहम्मद शरीफ न्यायालय में स्वयं उपस्थित है, जो काफी वृद्ध है। उपरोक्त तथ्यों और संलग्न कागजातों एवं अंचल अधिकारी सदर हजारीबाग द्वारा
So
प्रेषित
therefore, the authority decided that the name of Munni Devi was wrongly deleted
yes,
and subsequently
not
also
deleted wrongly, not inserted because
wrongly
changes-
not inserted,
yes,
and that was an error, right? Some false document or whatever was produced, and ultimately your name has been missed. That's it. So how do I get that on the date
because
when the
the
document
plaintiff is not selling the entire land to me. Kindly come to the paragraph 3 and 4. He says I am sharing my share to you, and his share along with the mother is not even the half of that. It is 8 acres, out of which he is selling me only a small piece of 2 acres.
कोई हिंदू और पार्टीशन के हिसाब से मुस्लिम लॉ नहीं चलता है, मुस्लिम लॉ का अपना निवांसेस है।
But how it can be?
No, not a case for specific. On the basis of your experience.
Something which is not on record, I cannot see that is there. Which is there, I can show.
You have
By
not
this
deposed
order-
any child.
By this order, my name has been entered into registered book.
Your name.
Yes, Lord, subsequently, kindly see note. Subsequently, उपयुक्त तथ्यों एवं संलग्न कागजातों तथा अंचल अधिकारी सदर हजारीबाग द्वारा प्रेषित प्रतिवेदन से स्पष्ट होता है कि अपीलार्थी मोहम्मद शरीफ, that is this intervener, मोहम्मद इब्राहिम माता स्वर्गीय मुन्नी,
कहाँ पढ़ रहे हैं आप?
यही उसके बाद जहाँ से रुके छोड़े वहाँ से
जहाँ छोड़ा। पेज नंबर बताइए, लास्ट पेज पढ़ रहे हैं
हाँ
और
नहीं लास्ट पेज का जस्ट है सबसे लास्ट
अतः अभिलेख के संलग्न कागजातों
हाँ ये भी कर सकते हैं। अतः अभिलेख में संलग्न कागजातों अंचल अधिकारी सदर हजारीबाग द्वारा प्रेषित प्रतिवेदन तथा सत्यापित कागजातों के आधार पर अंचल अधिकारी सदर हजारीबाग के दाखिल खारिज वाद संख्या 100 को पारित आदेश को निरस्त करते हुए आवेदक के आवेदन को स्वीकृत किया जाता है। अंचल अधिकारी सदर हजारीबाग को आदेश दिया जाता है कि अपीलार्थी आवेदक का नाम और तहसील का खाता नंबर 6 कि भूमि का उत्तराधिकारी नामांतरण के आधार पर ऑनलाइन प्रविष्टि करने की
और
कार्रवाई
अपीलार्थी कौन
सुनिश्चित
है?
है। अपीलार्थी दैट इज मोहम्मद शरीफ, दिस इंटरव्यूअर
No, that is my
दिस इंटरव्यूअर मोहम्मद शरीफ।
my
कहाँ से बोल रहे हैं
ये
अपीलार्थी?
फर्स्ट पेज अपील दाखिल खारिज बात संख्या 11/2013-14।
पेज नंबर बताइए।
पेज नंबर तो इसका ये नहीं।
Mohammed Sharif is my vendor also.
मोहम्मद शरीफ दिस इंटरव्यूअर
Mohammed Sharif is my
बनाम राज्य एवं अन्य अपील दाखिल खारिज बात संख्या 11/2013-14।
Mohammed Sharif is defended, sole defendant.
रजिस्टर्ड नोटिस आपका कहाँ से ऑर्डर शुरू होता है ये? The defendant is Mohammed Sharif. Father's name is Ibrahim.
Yes. As proposed interveners are Muhammad Riyad and Muhammad Wasim. If he is saying anytime
We are the son of Muhammad Wali Muhammad, late Wali Muhammad.
the interveners here
आप अननेसेसरी डिस्टर्ब कर रहे हैं। अभी आपका कोई एंट्री टिकट नहीं मिला, तो आप बैठ जाइए ना प्लीज। नहीं ऐसा करिए, नहीं कुछ नहीं असिस्ट कर रहे हैं आप, और डाइवर्ट कर रहे हैं। So according to the record,
as those things
your
which are
the
not on
name
record
of your
are
mother
not-
was required to be entered. The name of your mother was required to be entered.
that was entered.
That was entered by virtue of the impugnment.
Yes.
That was rectified, and since she had already died, only your name was entered.
Yes.
What is the date of death?
Look, in
I'm
his
stuck with
name, there is no document to show.
There is nothing in the agreement that she has expired, and there is nothing in the agreement that you are authorized on her behalf to execute any sale deed.
Yes.
These two things are
Yes.
conspicuously missing.
Yes. Something which is not there, I will not make a submission that is there. And once he has said Muhammad Ibrahim, I myself has become confused. आदमी को ऐसा दिखा अचानक कैसे?
अच्छा, और क्या exhibit है आपका? बताइए।
The another exhibit is registered notice which was sent and the Khatiyat.
Where is the
Name
registered
of Cheri
notice?
Deepda.
Where is the registered notice?
Registered notice is exhibit 2.
Exhibit 1 तो दिख रहा है।
Exhibit 1 is original agreement, exhibit 2 is registered notice.
Photocopy of खतियान।
Khatiyat.
List of documents filed. Original agreement and photocopy of खतियान। यही दिख रहा है हमको list of documents filed.
Exhibit 2 has.
Certified copy of the खतियान has been exhibited.
Yes, certified copy of Khatiyat is also exhibited. That is.
नोटिस का है, नोटिस का एक हमको खाली रजिस्ट्री वो दिख रहा है।
नहीं हिंदी में नोटिस है पूरा ऑर्डर शीट की तरह।
अच्छा, रजिस्टर्ड नोटिस
हाँ,
रिमाइंडर।
registered notice।
अच्छा, तो ऑर्डर शीट टाइप से लग रहा है।
इसीलिए वो ऑर्डर शीट की तरह दिखता है। दिस इज एग्रीमेंट। वजह है कि आप नोटिस पाबंदा जायदाद मालिकान रजिस्टर नंबर 11 खाता 6 मौजा सिरका थाना हजारीबाग थाना संख्या 146 जिला हजारीबाग में सह खातेदार हैं। तफसील जमीन प्लॉट जिसका पूर्ण विवरण नोटिस आजा के अंत में दिया जा रहा है। आपने उक्त जायदाद में स्थित अपनी वैधानिक 1/3 अंश रकबा 2 एकड़ 84 डिस्ट्रिक्ट where it is written mother is dead, but what he is selling is his share. Why? And why? Mother has died. One line written in para 4 of my claim.
When?
That is not mentioned. The defendant further disclosed that after death of his mother and father, he is in possession of 1/3 of the lands of Khata number 6, village Sirka, yes, that one line is there. 7 except that date of death is not.
This is on the title of the vendor. Prima facie satisfaction regarding the title of the vendor.
Title of the vendor, I will say is not required to be looked into in the suit for
Prima facie satisfaction regarding
Prima
the
facie
title
satisfaction.
has to be there.
Yes. Yes.
Now, what about your readiness and willingness?
My readiness and willingness kindly see two aspects of the matter.
Let me see your claim. What have you stated about your readiness?
Readiness and willingness is a question of fact.
Yes.
If I approach the court within 6 months of my notice and within 30 days of that correction in name, that shows my willingness and readiness. The date of agreement is 12/9/2018. His mother's name is corrected in the revenue record on 31/1/2019, and when he is refused to do so, as per my plaint on 1/2/2019, I filed suit on 5/2/2019. So everything happened in 3 months, 3 to 4 months. So this shows that I am not sitting idle. Whatever.
What was the remaining consideration amount?
The remaining consideration is a huge amount. The remaining consideration from the agreement it was 4 point some crore. It's 9
Exact.
lakh, I think 4.435 or 4.
Exact. Deduct करके बताओ.
4 crores. 4 crore 36 lakh 28,500. Up to 4 crore 37 lakh 28,500.
4 crore 37 lakhs
28,000
28,000
500.
5. Correct?
Yes.
इतना अमाउंट कैश नहीं कितने देते? Specific performance of contract. Where is your readiness and willingness? Readiness and willingness are two things. You are willing, very good, you are willing. What? Where is readiness?
There is no evidence.
No evidence. Matter ends. कहानी खत्म.
Not to that extent.
Yes. There is no readiness and willingness because that is the basic ingredient. अभी नया judgment नहीं देखे हम लोग का judgment भी नहीं देखते.
Willingness, readiness, I have to show that.
Willingness to yes, I want to file a property of 4 crore.
Yes.
I am willing.
And readiness.
Where is the readiness?
Readiness, I will say that.
You have to plead and vote.
Yes. And the fact of two
And you have to
different-
say in your pleading that this much is available with you
Yes.
in wherever it is. Or you are in a position to take some loan and the person is ready to provide you a loan.
That is not.
दोनों चीज नहीं है.
Readiness है. Oh, sorry, willingness.
Willingness of course.
Willingness है. Readiness नहीं. That evidence is not. That I have tried to find out looking into that judgment itself. And when I asked my client, he has sent me as a photo stat of his check that this is my readiness. Photo. I said,
That
thank you very
check.
much. Thank you very much. That evidence is not. How can I improve a case? But still, I will say that there are two different situations. When the defendant appears and says, complaint says, a government is there about my readiness and willingness. Other side appears, makes a contrary stat that this aspect is denied. Then I am supposed to lead evidence.
No.
Then
That is
only,
not the law.
otherwise prima facie.
That is not the law. The readiness and willingness has to be pleaded and proved by the plaintiff. And the court, when the court has to execute the sale deed, the court will not execute the sale deed in air. After full satisfaction, the court will execute the sale.
And the court will not do the futile exercise
Yes.
that even decree is passed, I am not in position. These are the questions in my mind. This is what makes sense. And the last limb which I will say that if the suit is not decreed, the order 7 rule 7 will come. The fact remains that he has taken money from me. That has to be returned. I am not, because now I cannot file a money suit also, so I cannot be left remediless.
What amount did you file? Did you pay?
That
And in
is
what
the
manner?
agreement itself, 9 lakhs, it is written. The notice gives it further. That along with interest has, because that relief is any other relief.
You said that you paid it by check.
I say that this is the agreement, this is his signature. Those things are not in dispute. So that money
You said
at
that
least
you
will come
paid
back.
in.
The agreement says उन्होंने पैसा लेके साइन किया. Registered notice में जो है वो डेट में मेंशन है कि कब तक उनको क्या पैसा दिया. That is also not responded by him. प्लेट फाइल हुआ वो भी नहीं आए, नोटिस गया वो भी नहीं आया, अपील में भी नहीं आए. So how the court can presume that this money was, at least this money was not even paid to him? And therefore, this is the smaller relief which the court at least in terms of order 7 rule 7 can give. Because now that not remains the fact which I have failed to prove. The money is paid that and the witness is there. The plaintiff himself examined himself coming to the witness box. He says कि हम पैसा देंगे.
ये जरा आप अपने लीगल नोटिस में देखिए. मोड ऑफ पेमेंट.
उसमें चेक से भी पेमेंट किया. 15/10/2018.
लेकिन आपके एग्रीमेंट में पूरा कैश पेमेंट लिखा.
एग्रीमेंट पे कैश पेमेंट लिखा है. कैश
लेकिन आपके
एग्रीमेंट के बाद का डेट है ना 12/9/2018 को एग्रीमेंट हो गया. उसके बाद वो हमसे पैसा ले रहे हैं ना 15/10/2018 को चेक से 3 लाख रुपया लिए. फिर 29/10/2018 को
दिस इज पोस्ट एग्रीमेंट.
यस पोस्ट एग्रीमेंट एंड देयरफॉर दिस शोज
नहीं ये सारा तो नहीं आया है पोस्ट एग्रीमेंट का कहानी कि आप इतना पेमेंट किए. ऐसा तो नहीं आया. सिर्फ 9 लाख का पेमेंट का कहानी आया.
my submission is that
Submission is
that
audio.
this is the payment by check.
In your plaint, nothing has been mentioned about any payment post agreement.
पोस्ट चेक्स पेमेंट का
कुछ भी जिक्र नहीं है. आप लीगल नोटिस में इतना चेक से पेमेंट की बात कर रहे हैं. Post,
This is what happens when suit is started. So check payment what they say it is, and the bank passbook is with you. How can I tell you? क्योंकि वो केस चल रहा था उसके लिए वो पैसा लिए जा रहे थे 2 लाख 1 लाख खर्च लग रहा है ये पे किए जा रहे हैं.
hard time for the litigant, but we can't do anything.
Whatever law permits litigation will be up to that extent. But these are the thing which I can say that yes, this is bona fide on my part. I was continued to make payment to him. And these are the check payments. And the defendant is too much clever that he never appears before any authority, any court, no legal notice, nothing, he will never respond. And further payment is of 3 lakhs, 5 lakhs, 6.
आपका कहाँ एविडेंस है कि 9 लाख रुपया पेमेंट की?
It will come to the evidence of the plaintiff himself, Dinesh Kumar Paswan, paragraph 9. यह कि प्रतिवादी ने मुझसे 9 लाख रुपया नगद अग्रिम धन के रूप में लेकर अपने होशो-हवास में बिना किसी दबाव के 12/9/2018 को इकरारनामा गवाहों के समक्ष लिख दिया. Paragraph 9. And then the court puts me a question at paragraph 22.
प्लेंटिफ का क्या नाम है? अब्दुल रहमान.
नहीं, plaintiff का नाम है दिनेश कुमार पासवान. The plaintiff appellant is Abdul Rahman is my witness.
Okay.
Plaintiff witness number 3, Dinesh Kumar Paswan. Other witnesses have also said, if leadership will see it, other witnesses have said, paragraph 6, यह कि शरीफ अग्रिम राशि 9 लाख रुपए नगद लेकर उक्त इकरारनामा को पढ़ सुन समझकर सही पाकर अपना सही बनाया. And then he says to quote question paragraph 15 agreement मेरे सामने बना. Then witness number 2 Dhirendra Rathwar, he also says paragraph 6 मोहम्मद शरीफ अग्रिम राशि के रूप में 9 लाख रुपया नगद लेकर उक्त नामा को पढ़ सुनकर समझ पाकर अपना सही बनाया. And then quote question number 12 पैसा का लेन देन मेरे सामने हुआ था. 2 witnesses and then myself, this plaintiff appellant Dinesh Kumar Paswan, paragraph number 9 कि हमसे लेके प्रतिवादी मुझसे 9 लाख रुपया अग्रिम राशि के रूप में लेके अपने पूर्ण होशो-हवास में बिना किसी दबाव के 12/9/2018 को गवाहों के समक्ष लिख दिया. इकरारनामा गवाहों के समक्ष लिख दिया. So this is the evidence what I can show. 2 witnesses, myself, पैसा जिनके सामने पेमेंट हुआ है. So that is the sufficient evidence that leads to that payment.
So your case would be that even if the court did not grant the specific performance of contract, the relief to that effect, at least 9 lakhs was required.
9 lakh with some statutory interest has to be refunded because any other relief for which plaintiff is found, I have established before the court this much I have paid. I could not prove that this much I could also have been paid. But what I have paid is established fact.
There is a finding that you have paid this much.
The court says
the plaintiff has only relied upon the notice. Hence, the plaintiff has filed a suit for specific, but the defendant took the amount of rupees 9 lakhs. They both entered into the agreement and pursuant defendant assured that he shall execute. The plaintiff has several times requested him. Exhibited agreement, legal notice, posted receipt. The witness including has mentioned that defendant approached the plaintiff with the proposal of sale of land. That's it. The plaintiff has only relied, even though it may be true that had paid the balance consideration.
Yes.
It may be true that the plaintiff had paid the balance sale consideration, but it cannot be ignored that neither plaintiff nor witness examined agreement mentions the date on which such payment was done.
Yes.
The date of agreement itself, that is a wrong finding. इकरारनामा लिया, पैसा लिया और इकरारनामा बनाया. So saying that on 14/12 तो यही तो मेरा evidence है. How can a one line from evidence can be taken off and says कि नहीं इकरारनामा ही नहीं. This finding of the learned trial court, डेट नहीं दिया, डेट तो लिखा हुआ है, इकरारनामा बना दिया, इकरारनामा दिनांक लिखा हुआ है, each and every fine details, वैसा तो कभी एविडेंस नहीं आ सकता है. And the last relief for any other relief plaintiff, so this is the relief. No one can be left remedying this now after this much long time. Even if he will take money, he will not go anywhere, and I could not establish. That doesn't mean I'm just enrichment to him.
बताइए कहाँ है आप?
Yes, my lord.
9 लाख रुपए तो वापस होना चाहिए
इसमें
ना?
हमको
उसमें आपको
आगे हम थर्ड पार्सर my lord. माने इसमें इनका है और प्लेंटिफ का है और जो एग्जीक्यूट किए हैं उनका है.
Okay. For the learned counsel for the appellant, in spite of issuance of notice, nobody has entered appearance on behalf of the sole defendant. The proceeding was ex parte before the learned trial court also. However, one intervention application has been filed. The IA number
831 of 2025.
831 of 2025, wherein the intervener claims that the person with whom the plaintiff appellant had entered into agreement of sale did not have the title with respect to the property, and the title actually belongs to the intervener. He has also submitted that the petition seeking intervention was rejected by the learned trial court, against which he had filed CMP number 393 of 2022, and during the pendency of the CMP before this court, the learned trial court decided the case and dismissed the suit. The learned counsel has also submitted that the present appeal is a continuation of the trial trial court, and therefore the intervention may be allowed. The said intervention was pressed by the learned counsel for the intervener on 5/2/2022, and this court observed that the question of any intervener would arise only if this court is inclined to interfere with the appeal judgment. As the suit for specific performance of contract filed by the appellant plaintiff has been dismissed primarily on the ground that the plaintiff failed to show his readiness and willingness to perform the contract and pay the balance amount of the consideration. यही reason है, टाइटल में क्या ही जाना है? That should be sufficient. इससे ज़्यादा बोलने में बहुत दिक्कत है. However, the counsel for the intervener has remained present during the court proceedings. and has also referred to the, that should be sufficient. The learned counsel for the discussing. Title suit was filed by the appellant, bearing title suit number 31 of 2019 against the sole defendant respondent herein. And prayer was made to the following effect. 1. To adjudicate and direct the defendant to receive balance consideration amount and execute sale deed in favor of the plaintiff for his 1/3 share in Schedule A. Roman 2. The defendant be restrained to sell the said suit land by granting injunction, cost and any other relief. The case of the plaintiff was that, as per the plaint, was that the defendant had approached the plaintiff and disclosed that he was in possession of an ancestral property situated in village Sirka, PS Hazaribagh under Khata number 6, and stated that the said property had total area of 8.52 acres, recorded in the name of Chedi Saudagar. After his death, only son Abdul Hafiz came in possession, and after death of Abdul Hafiz, the property came in possession of two sons, namely Sabrun, Muhammad Hanif, and one daughter Munnu, the mother of the defendant. It was his case that after death of his father, mother came in possession of 1/3 share of the land. The defendant approached the plaintiff and after negotiation, the plaintiff agreed to sell his land on fixed consideration of rupees यहाँ पे consideration amount क्या लिखा है 6285
per kattha.
अच्छा
That is for
fixed
1/3
consideration
share.
of rupees 62,000
6,20,000.
6,28,571 per kattha, and the defendant's share, and both the parties agreed, and the defendant's share of 1/3 was 2 acre 84 decimal, and the total consideration was rupees 44 lakhs
4 crores.
4 crores 46 lakhs 28,541. The defendant took rupees 9 lakhs as advance money for executing the agreement in favor of the plaintiff, and assured that he will execute the sale deed in favor of the plaintiff after obtaining required papers like land possession certificate and other documents. It was a case of the plaintiff that the plaintiff approached the defendant several times and requested to receive the balance consideration amount to execute the sale deed, but the defendant, on for some pretext or the other, kept on delaying the matter. It was also asserted that the advanced money was paid and the execution and the sale deed was executed and the agreement was executed in presence of witnesses at Hazaribagh on 12/9/2018. The plaintiff could learn that the defendant had obtained the required paper on 20/12/2018 and on 20/12/2018 the plaintiff asked the defendant to receive the consideration money and execute the sale deed, but the defendant deferred the matter. And ultimately, the plaintiff sent a legal notice requesting the defendant to receive the balance consideration money and to execute the sale deed. But the defendant refused to receive the legal notice. And ultimately, the plaintiff went to the house of the defendant, met and asked him to receive the balance money and execute the sale deed. But the defendant finally refused to execute the sale deed and stated that he will sell the land to some other person. As per the claim, the cause of action arose on 12/9/2018 when the defendant executed the agreement for sale and on 1/2/2019 when the defendant finally refused to execute the sale deed in favor of the plaintiff. And thereafter the suit was filed on
Suit was filed on 5/2/2019.
5/2/2019 seeking specific performance of contract. With the relief as mentioned above. It is the records of the case also reveal that it is not in dispute that in spite of service of notice, the defendant did not appear to contest the plaint and accordingly no written statement was filed, nor the defendant appeared to cross-examine the witnesses. The proceeding was ex parte.
Ex parte by order dated 27/2/2020.
By order dated 27
to
to 2025. इतना जल्दी
2020.
2020. By order dated 27 to 2020. On behalf of the plaintiff, altogether 3 witnesses were examined. And the plaintiff was himself examined as witness number 3.
3W3.
Property is situated where?
Property civil or property right itself. Hazaribagh. The details are given in the civil of the claim. Claim paragraph 8. Lands at village Sirka, PS Hazaribagh, PS 147. 146.
At Hazaribagh, right?
Yes.
So far as plaintiff witness 1 is concerned, he has claimed that he knows both the parties. And that the plaintiff wanted to live in Hazaribagh after retirement. And that the defendant had offered to sell the property, and an agreement was prepared on 12/9/2018. He also deposed that the defendant took rupees 9 lakhs in cash and read the agreement and put its signature. And the plaintiff had repeatedly asked the defendant to execute the sale deed pursuant to the agreement, but he did not. Agree.
Lord, the question number 15-16 report question. एग्रीमेंट मेरे सामने बना है जमीन का लेन
इसका
देन
तो वो लिख ही नहीं पाया 15-16.
सर्टिफाइड कॉपी यस
अच्छा एक to the court question,
यस
he has responded that
15-16 question
in paragraph 15 and 16, he has stated that the agreement was prepared in his presence and the transaction in connection with the property had also taken in his presence. So far as witness number 2 is concerned, he has also stated that he knows both the parties and that he has also deposed in the same line as that of PW1 and to the court question
para 11 and 12
in paragraph 11 and 12 he has stated that he was present at the time of transaction between the parties.
money was also
11 and 12. Yes. He has stated that, however, he has not signed on the agreement, but the agreement was executed on 12/9/2018. So far as the the witness number 3 is concerned, he is a plaintiff himself. He has stated that he is the plaintiff and he is the permanent resident of Hazaribagh. And that the defendant has expressed that he wanted to sell his property. He has further stated that the property was recorded in the name of Chedi Saudagar, who had one son, namely Abdul Hafiz, who entered into possession of the property. Abdul Hafiz had one son, Mohammad Hanif, two daughters, Munni and Saburan. And after death of Abdul Hafiz, there was a partition amongst the family members, and the property mentioned in Schedule A fell in the share of Munnu, on which she entered into possession. Munnu also expired, leaving behind the sole son who was a defendant in the case. And that the plaintiff entered into an agreement of sale with respect to Schedule A property, whose total value was rupees 4,46,28,541, and the plaintiff had paid rupees 9 lakhs cash, and agreement was entered into with respect to sale of the property on 12/9/2018. The agreement was exhibited by the defendant and marked as Exhibit 1. He stated that the defendant, by the plaintiff marked as Exhibit 1, he stated that the defendant assured him that after getting LPC certificate, the registry of the property will be done, and he had repeatedly asked the defendant to take the remaining amount and execute the sale deed. But the defendant did not do the needful, and ultimately a legal notice was sent on 1/1/2019, which was marked Exhibit 2 and 3. And in his evidence, he has stated that in spite of receiving the notice, the defendant did not reply. जबकि एक पे refusal है ना, refused to plaintiff.
Plaintiff may refuse to accept लिखा हुआ है, but there is no such refusal is produced before plaintiff. Yes.
Then he met the defendant on 1/2/2019. जहाँ एक जगह लिखी है ना refusal to accept, इसको बोल्ड करके छोड़ो. ऊपर लिखे हैं refusal to accept. Then he met on 1/2/2019 and wanted to pay the remaining amount, but the defendant did not agree, and ultimately the suit was filed. To the court, he has stated
Para 23, 22 lines. 22, 23.
para 22 and 23
That he has paid 9
that
lakhs.
he has paid rupees 9 lakhs in cash, and by making payment,
Three persons were
three persons were present. And he has stated that the property has not been partitioned. इसमें लिखा है बंटवारा नहीं हुआ. Para 24
This जमीन का बंटवारा नहीं हुआ.
has not been.
In that context, 8 एकड़ का बंटवारा 3 legal years में. हाँ ठीक. बंटवारा नहीं हुआ, means 2.4 एकड़ जो है उसका बंटवारा. 8 का बंटवारा होता 2.4 हुआ. 2.4 का फर्दर बंटवारा.
The evidence of all the witnesses revealed that there was an agreement of sale dated 12/9/2018 in their presence, and an amount of rupees 9 lakhs was also paid as advance money. Further, the agreement of sale also reveals payment of rupees 9 lakhs in advance. However, the specific case of the plaintiff was that apart from the aforesaid documents, the plaintiff has also exhibited the ये exhibit number कितना है?
Exhibit 2 is legal notice and Khatian and this one is exhibit 3. Order of additional collector.
Has also exhibited the order of additional collector bearing mutation appeal case number 11 of 2013-14 dated 31/1/2019, wherein it has been recorded that the name of Munni, the granddaughter of Chedi Saudagar, was not entered into the register
Revenue records.
in the revenue records, and the same was sought to be rectified by the order. And since Munni had already expired, the name of the defendant was entered in the register, in the revenue register.
Yes.
The records of the case further reveal that the plaintiff claimed the property through his mother, Munni Devi.
Through the mother of the defendant.
Through the mother of the defendant, through the mother of the defendant, Munni Devi. The agreement of sale reveals the name of the persons who were descendants of Chedi Saudagar and who had expired. But the agreement reveals the name of the mother of the defendant, but it does not reflect from the agreement that the mother of the defendant had expired. During the evidence also, and during the course of argument, the learned counsel for the appellant has not been able to show any material from the records with respect to the date of death of the mother of the defendant. Nor any of the witnesses have deposed regarding the date of death of the mother of the defendant. In such circumstances, when the mother of the defendant had not expired, it cannot be said that the entire 1/3 of the property devolved upon the sole defendant. The question of devolution of 1/3 property on the sole defendant could arise only if the mother had expired prior to execution of the sale, of the agreement of sale. This foundational fact regarding date of death of mother being absent and the proceeding being expired. This court is of the view that the claim of the plaintiff that defendant would have executed 1/3 share which could have devolved upon him through his mother is also not established. Admittedly, in the agreement, neither the mother is a party, nor there is anything to show that mother had authorized the defendant to execute the sale deed on her behalf also. And the agreement is to the extent of 1/3 of the property which would have devolved upon the defendant, which would have devolved upon the defendant upon after death of his mother. This court also finds that apart from the aforesaid, the learned court has considered the basic ingredient for granting specific performance of contract. One of the basic ingredients for granting specific performance of contract, that is readiness and willingness to perform the agreement. The learned court has recorded a finding though the learned court has not framed any point of determination as such, but certainly the court has considered one of the prime ingredients of readiness and willingness to perform the agreement. The learned court, while considering the aforesaid aspect of the matter, has referred to the provision of law and also various judgments of the Honorable Supreme Court, particularly with respect to Section 16(c) of the Specific Performance Act, and has recorded the following findings. Page 50 से internal pages का 19 से 22 तक कोट है. This court finds that there is no specific pleading. एक judgment है 2024 का हम बाकी सब cases में consider किए हैं. I will just put it अभी हमको याद नहीं judgment. And this court finds that the plaintiff has miserably failed to plead and prove the availability of fund to the extent of balance consideration amount of rupees 4,37,541, and mere statement that he is ready and willing to perform his part of the contract is not sufficient. This court is of the view that the learned trial court has rightly held that there was no readiness and willingness on the part of the plaintiff to perform his part of the contract, and has rightly refused to decree the suit for specific performance of contract. This court also finds that there was sufficient material on record to show that the plaintiff had paid rupees 9 lakhs. Such evidence was supported by the witnesses, as discussed above, and such evidence was sustained by all the witnesses, even when specific questions were put by the concerned court. Specific pleading to that effect was also made in the plea. In view of the aforesaid materials placed on record when the proceeding was ex parte and the defendant neither filed the written statement to oppose such pleading nor took part in the proceedings to cross-examine the witnesses. This court is of the considered view that the execution of the agreement and the payment of rupees 9 lakhs, which was duly mentioned in the agreement of sale and also supported by witnesses and also mentioned in the plaint, stood duly proved. And therefore, the finding of the learned court that it could not be ascertained as to when the payment of rupees 9 lakhs was made is not sustainable in the eyes of the court. Consequently, even after holding that the plaintiff is not entitled for specific performance of contract, this court is of the view that the plaintiff was certainly entitled for refund of rupees 9 lakhs, which was paid by the plaintiff to the defendant. Accordingly, this court directs the plaintiff to directs the defendant to deposit rupees 9 lakhs. कहाँ पे होगा? Before the court?
Before the court, failing which I will.
Before the court, along with interest of 6% per annum from the date conserved
12/9/2018.
from
Date
12/9/2018 till the date of payment within a period of 3 months from the from today. Yeah, from the date of receipt of a copy of this judgment.
Since it is the first appeal, that date cannot be. If I found entitled, he is directed to refund.
Within the period of 3 months, in case the amount is not paid, it will be open to the appellant to get a refund of the said amount, to realize that amount through the process of law. हमको तो सजाना पड़ेगा, हमारा अपना पॉइंट ऑफ डिटर्मिनेशन बनाना पड़ेगा. याद रखिएगा सौरभ, इसमें एक पॉइंट ऑफ डिटर्मिनेशन हम लोग का होना जरूरी है.
Court has done in the same way. Therefore, benefit has to be paid.
Point of determination regarding readiness and willingness. Do you think उसका टाइटल पर इतना जाने का जरूरत है?
Point of determination will be whether I have got valid cause of action. That will be answered that yes I have because there is an agreement. Then another point of determination whether I am able to establish the readiness and willingness on my part. That will be answered against me that no. Whether I am entitled for any other relief, yes I am entitled for refund. These three will be the point of determination.
तो वो टाइटल में जाना जरूरी है?
It's not necessary.
Not necessary.
There are Supreme Court judgment which says title has nothing because it cannot be decided there.
ऐसा सौरभ इसको ना थोड़ा सा जो टाइटल वाला क्वेश्चन है, हमको लगता है कि क्योंकि डिपेंडेंट भी नहीं
If
है
title can be looked into, his intervention also can be.
Section 17 जो है specific purpose.
थोड़ा सा उसमें एडर.
Section 70 may place. Section 70 says about vendor. अगर vendor का खुद का title
नहीं, लेकिन ये ऑब्जर्वेशन कि कब डेथ हुआ है ये नहीं है.
required. It's not required. And what he is saying, section 70 is that if I don't have any title and I make an agreement with him, and if he is not paying money, and if I want suit for specific performance, then section 70 is for his defense, that you cannot ask me to give you further amount since you don't have title. It is not vice versa.
एक सेकंड ये लिखिएगा. Point for determination में whether there is a valid cause of action. Second is whether
Plaintiff has sufficiently proved readiness and willingness on its part.
Whether the plaintiff has proved the readiness and willingness on its part, and third is whether the plaintiff is entitled for any relief. So these are the three. उसके बाद एक और लिखिएगा. Since this court has this court is not inclined to interfere this court has also upheld the judgment of the learned trial court to the extent it has refused to grant specific performance of contract to the plaintiff appellant. There is no further need to allow the intervention and hear the interventions.
Therefore, my appeal has to be allowed in part, and the decree has to be prepared for refund of 9 lakhs.
This appeal is disposed of in the aforesaid terms. दो पार्ट रहेगा. अभी just last में हम उसको कर देंगे. Decree office is directed to prepare appropriate decree for refund of rupees 9 lakhs with interest at the rate of rupees 6% as indicated. हमको लगता है हो सकता है टाइटल वाला पार्ट हम हटा दें. कोई जरूरत
I
नहीं.
myself will submit that there cannot be two way. The leadership will dismiss my appeal saying title is not required to be looked into. At the same time, interventions application will also decide that I will
Maybe
not.
let me see थोड़ा सा होगा. हो सकता है वो portion हम हटा ही दें.
Title is
Petition
not
में दे दिए हैं
required to be
because
looked into. That is my submission. Also, leadership may require that this question is not required to look into because suit for specific performance. Neither I am supposed to give evidence, nor the court is required to adjudicate this aspect. Whether the vendor has got title or not. That will not.
एक चीज और आती है. However, this court finds that there is no question of entering into the title
Question
of the plaintiff, but the aforesaid observation has been made based on the arguments and queries put by the court to the learned counsel for that. वो कहानी उसका रिगर सब भी खत्म हो जाएगा. ठीक है?
Yes. Right.
गोटाइटी को बोलेंगे ना कि जजमेंट में 2-3 जजमेंट हैं स्पेसिफिक. आप भी दिए हैं कोई? है ना सेक्शन 16 से नया जजमेंट है. उसमें एक था विभोर बैंक ने आर्ग्यू किया था वो मैटर और पहला हम वही डिसाइड किया. उसके बाद एक और हम किए हैं ये रेडिनेस एंड विलिंगनेस पर कि कैसा प्लीडिंग और कैसा प्रूफ होना चाहिए. इसकी जरूरत नहीं पड़ी.
But to some extent that court is supposed to make a point of determination. Because on that day leadership will put a question.
Is it required?
This is no, not required.
Not required for this. Certainly this is an important judgment. क्योंकि readiness and willingness consider कर ही लिया है.
And this is the point where I cannot improve my case.
चलो इतना चेक वेक की बात कर रहे हैं. I just very difficult. नोटिस बिना देखे ये प्लेन बना के फाइल हो.
That is.
ऐसे हेस्ट में ऐसे ही होता है.
He is giving me the evidences which I right now have. Okay.
Item 7, first appeal 1117 of 2024.
हाँ बताइए.
उसमें कॉम्प्रोमाइज हो गया था लोअर कोर्ट में.
कॉम्प्रोमाइज हो गया.
जी उसके बावजूद भी ठीक किया नहीं गया. क्योंकि एक मैंडेटरी प्रिंसिपल ऑफ लॉ है कि if there is compromise, no option is left for the trial court, save and except to pass a decree on the basis of compromise. So let's say last week में हमने कंप्लेंट दिया citation का.
What is the reason for not accepting the compromise?
इसमें लोग से हमें जो एग्रीमेंट को पढ़ते हैं तो कोई विशेष स्पेसिफिक रीजन नजर नहीं आता. ये और भी क्लियर है. पर्सनल जो हम एग्रीमेंट पढ़ लें वादी की बात का सबसे साथ ये है
कहाँ लिखी है?
जी ये जो जजमेंट है पेज नंबर 62 पेज नंबर 1 में आएंगे।
पेज नंबर
रनिंग पेज 62 है और
62
और
हाँ
रनिंग
बताइए
पेज 1
पढ़िए।
वादी द्वारा वर्तमान प्रतिवादी के विरुद्ध विवादित संपत्ति पर स्व प्रतिकार लिखित की घोषणा हेतु दाखिल किया गया है। वादी के बाद का संक्षिप्त सार यह है कि विवादित संपत्ति से खाता नंबर 16 है। प्रतिवादी बागेश्वरी देवी ने निबंधित विक्रय पत्र विलेख संख्या 16 के माध्यम से क्रय किया था। उसके पश्चात राज्य कार्यवाह समिति निर्धारित आदेश दिनांक से 2/7/1990 के द्वारा क्रम दाखिल खारिज कराया। प्रतिवादी विवादित भूमि के सातवें पर्चे में दिनांक 20/7/1994 से है। वर्ष 2005 में प्रतिवादी को पैसे की आवश्यकता हुई तो वादी ने विवादित संपत्ति को क्रय करने की इच्छा जताई थी। वादी ने दिनांक 10/5/2005 को संपूर्ण राशि 1,51,000 रुपये का भुगतान प्रतिवादी को कर दिया। प्रतिवादी ने 15 दिन का समय लिया तो विक्रय विलेख करने, परंतु वादी के बार-बार विनती करने पर भी वो टालमटोल करते रहे। 1 महीना बीत गया। उसके बाद जब प्रतिवादी ने विक्रय विलेख निष्पादित नहीं किया तो वादी जबरदस्ती वैध भूमि में आ गए और रहने लगे। दिनांक 23/6/2005 से ही वादी संपत्ति मालिक के विरुद्ध उनकी जानकारी में उनके संपत्ति में रहने लगे और आज तक रह रहे हैं और किसी के द्वारा कोई प्रतिरोध नहीं किया गया। वादी द्वारा संपत्ति विवादित भूमि पर चारदीवारी कराई गई और एक घर का निर्माण किया गया। वादी का कथन है कि वादी को प्रतिकूल कब्जे के आधार पर विवादित संपत्ति पर उसके स्वर्ग अधिकार की घोषणा की जाए।
प्रतिकूल कब्जा adverse possession.
Adverse. तो इस पर भी
So you are claiming adverse possession and then you are also claiming right title interest possession over the property
on the basis of adverse possession.
only on the basis of adverse possession.
Yes.
लेकिन you are claiming title. अच्छा स्वात्य अधिकार.
I am getting title on the basis of.
Okay, you are claiming title only on the basis of adverse possession. तो आपका पोजीशन कब से है?
मेरा पोजीशन 23/6/2005.
23/6/2005. And you say that you forcibly entered into the property. Forcible entrance is for.
That is not permission. I had not been allowed to enter in that very premises.
Okay. 12 साल कब खत्म?
23/6/2017.
सूट कब फाइल की?
सूट फाइल किए
2023.
2023.
आगे बताइए. रिटन स्टेटमेंट फाइल हुआ?
जी, डब्ल्यूएस फाइल हुआ, ऑर्डर 12 रूल 1 में फाइल हुआ। उन्होंने हमारे सारे क्लेम को एडमिट किया। तो इसमें इशू बनने का कोई प्रश्न नहीं था क्योंकि ऑर्डर 14 के अनुसार देयर मस्ट बी सम डिनायल एंड
रिटन स्टेटमेंट वाज फाइल्ड अंडर ऑर्डर
12 रूल 1.
12 रूल 1. ओके, सीपीसी.
जी। तो
समझौता भी हो गया मीडिएशन.
जी हाँ, मेडिएशन समझौता भी हुआ। इस बात को उन्होंने इसमें सारा एविडेंस आया कि भाई हम एक्सेप्ट करते हैं कि पैसा हमने रिसीव किया था। ये सारा कुछ इसमें है और ये भी जो एक्नॉलेजमेंट है कि पैसा रिसीव का वो भी वहाँ पर।
जब मीडिएशन में ये हो गया तो फिर क्या ही बचा इसमें करने के लिए?
यूनिवर्सिटी ये आश्चर्य है कि ऐसा क्यों, मतलब ये केस नहीं है हमारे पास और भी लोग अपनी फाइल करते हैं जहाँ कहीं कोई ऐसा नहीं है कि सरकारी जमीन हो या कुछ ऐसी बात हो कि यहाँ तो सब कुछ जो है इवन ये दोनों जो है सो इनकी जाति में देखी जाएगी तो दोनों ब्राह्मण हैं, फिर भी कंप्रोमाइज इवन एक पार्टीशन सूट हम दे रहे कंप्रोमाइज पर भी डिस्कस कर दिया गया अभी, मतलब लगता है 15 दिन पहले की बात। और इसमें जो उन्होंने जजमेंट साइन किया है ये पटना हाई कोर्ट का भी है और वेस्ट कोर्ट का भी है, उड़ीसा हाई कोर्ट का है और मध्य प्रदेश हाई कोर्ट का भी है कि यदि कंप्रोमाइज हो जाता है तो केवल पार्टीज के ऊपर बाइंडिंग नहीं है। आप यदि जजमेंट पास भी होता है तो थर्ड पार्टी का यदि इसमें कोई तरह का इंटरेस्ट भी है दैट वुड नॉट बी बाइंडिंग ऑन थर्ड पार्टी। तो ये मतलब बियॉन्ड जो मैंडेटरी प्रोविजन ऑफ लॉ है उसके बाहर जाके अननेसेसरी फ्लड हो रहा है हमारा अपना ऑनरेबल हाई कोर्ट ऐसे फर्स्ट अपील से, इससे कोई जरूरत नहीं है।
ये जरा पढ़िए तो पेज नंबर 9 में क्या लिखा है?
जी ये इंटरनल पेज है ना,
हाँ
एक्सक्लूसिव ऊपर से पढ़ेगा
नहीं,
एक्चुअल
उपरोक्त वाद बिंदु के निर्धारण के लिए ये जो 2, 3, 5 इंटरनल पेज 9 लास्ट पेज लास्ट हाँ ये शायद जो इशू
हम लोग इसमें एक और बना
1, 2, 3, 5 एंड 5, 1
निष्पादित किए जाते हैं।
हाँ
उपरोक्त वाद बिंदु प्रतिवादियों के द्वारा प्रसिद्ध नहीं की गई, नहीं किसी ऐसे तथ्य का उल्लेख अथवा परिस्थिति स्पष्ट की गई जिससे स्पष्ट हो कि वादी का वाद वर्तमान रूप में घोषणीय नहीं है। वादी का वाद निबंधन अभित्यजन एवं प्रतित्व तथा परिसीमा के नियम से बाधित है। तदनुसार वाद बिंदु संख्या 1, 2, 3 और 5 निष्पादित किए जाते हैं। मतलब वो जो इशू सेटल किया गया था उसमें
cause of action
जी, cause of
limitation
action, जी,
limitation कैसे बाधित है?
कैसे इसमें तो ये निष्पादित किए जाते हैं मतलब हमारे पक्ष में ऐसा कहना होगा कि हमारे पक्ष में
निष्पादित किए जाते हैं मतलब किसके पक्ष में?
इसमें लिखा हुआ नहीं है और सिर्फ extremely correct, but is that is essence of that line is that these are being decided in favor of the plaintiff, although it is not specifically written.
In favor of the plaintiff.
You know, इसे कहने का मतलब यही प्रतीत होता है।
प्रतिवादी द्वारा प्रेषित नहीं किया गया।
हाँ, तो उसके नियम से
जिससे स्पष्ट है कि वादी का वाद वर्तमान रूप में पोषणीय नहीं है। Not maintainable.
लेकिन इसमें उपयुक्त
conflicting
जो कि उसको फिर से पहला नहीं पढ़ते हैं। उपयुक्त वाद बिंदु प्रतिवादियों द्वारा, ऐसे तो प्रतिवादी एक ही है, द्वारा प्रेषित नहीं की गई है।
हाँ।
प्रेषित
आगे पढ़िए।
नहीं की गई है कि ऐसे तथ्य का उल्लेख अथवा परिस्थिति स्पष्ट की गई है जिससे यह स्पष्ट हो। दोनों में ऐसा कुछ नहीं कहा। जिससे यह स्पष्ट हो कि वादी का वाद वर्तमान रूप में पोषणीय नहीं है। ऐसा उन्होंने कुछ नहीं लाया कि वादी का वाद पोषणीय है। और
कॉम्प्रोमाइज जो हुआ था वो कहाँ है? ये तो मीडिएशन में कॉम्प्रोमाइज हुआ था, कॉम्प्रोमाइज यहाँ पे एग्जिबिट हुआ है? वो कौन सा एग्जिबिट नंबर बताइए? एग्जिबिट नंबर
3 है वो, पेज नंबर 88।
एग्जिबिट 3 तो खाली ओरिजिनल रेंट रिसीट है, as per the judgment।
नहीं तो सोच एनेक्सर 3 है।
एनेक्सर से कैसे होगा?
अच्छा ये एग्जिबिट कितना है तो कंप्रोमाइज पिटीशन है वो एग्जिबिट एनेक्सर 3। तो कंप्रोमाइज पिटीशन के तो एग्जिबिट होने की जरूरत नहीं है।
कॉम्प्रोमाइज जॉइंट कॉम्प्रोमाइज कहाँ है वो?
वो एनेक्सर 3 है।
लोअर कोर्ट में होगा? रिकॉर्ड पर होना चाहिए।
जी हाँ।
पेज नंबर बताइए।
88।
ये कब फाइल हुआ है?
फाइल जो है 30 अगस्त 2023 को।
ऑर्डरशिप में होना चाहिए।
जी बिल्कुल, ऑर्डरशिप में इसमें भी आएगा।
30 अगस्त नहीं, जजमेंट में कहाँ आया है कि जॉइंट कॉम्प्रोमाइज फाइल?
जी,
जजमेंट में आया है कि मीडिएशन में सेटल हो? खाली जजमेंट में कहाँ आया है कि जॉइंट कॉम्प्रोमाइज फाइल? लेकिन हम उसको नहीं मानेंगे।
पेज नंबर 4 में लिखा है, इंटरनल पेज जो जजमेंट है उसमें आ जाएगा।
पेज नंबर 4 बताइए।
अब प्रतिवादी संख्या 1 ये हो गया 1 2 3 चौथा पैराग्राफ।
हाँ बताइए।
कैटेगरी संख्या 1 श्रीमती बागेश्वरी देवी ने अपने मुख्य परीक्षण में कहती है यह कि वो इस वाद की प्रतिवादी है, उसके एवं वादी के साथ सुलह हो चुकी है, उसके वादी का सिर्फ संधि पर इस वाद में दाखिल हो चुका है, जिस पर उसके वादी और उनके अपने का हस्ताक्षर है। ये ऑर्डर जजमेंट नहीं है।
एग्जिबिट नहीं मानते, होता नहीं है।
नहीं ये जॉइंट पिटीशन नहीं होता है, वो पार्ट ऑफ डिग्री होता है। ऐसा प्री रिड्यूस में है तो पार्ट ऑफ डिग्री बन जाता है।
तो जो रिकॉर्ड आया है खुद से उसमें होना चाहिए।
निश्चित
कौन से ऑर्डर शीट में इसका एंट्री है, कौन से
ये
दिन
जो
फाइल हुआ
इंटायर
है?
ऑर्डर शीट है उसमें 30 अगस्त का ऑर्डर देखा जाएगा।
30
30/8 का उस ऑर्डर शीट में निश्चित होना चाहिए कि फाइल
A
किया
joint compromise petition has
जी।
been filed on behalf of both the
जी।
sides are directed to appear physically
जी
under order
23/1 and 2
order 23 होगा, order 10 लिख रहा है।
ऑर्डर 10 लिखा गया है कि ये इसके लिए मेडिएशन में जाने के लिए, इससे कंप्रोमाइज फाइल हुआ है ऑर्डर शीट,
अच्छा,
तो ऑन द बेसिस ऑफ कंप्रोमाइज
तो order 10 में गया था क्या?
ऑर्डर 10 में गया।
order 10
मैं मेडिसिन ऑर्डर 10 नहीं आता है।
ठीक है, order 10 rule 1 and 2।
नहीं ऑर्डर 10 केवल
तो ये rule क्यों लिखा साथ में?
गलत है, ऑर्डर 10 जो है स्पेसिफिक है।
ओके, उसके बाद क्या हुआ?
उसका मेडिसिन में भी गया, वहां से भी सक्सेसफुल होकर के आया।
Mediation center, mediation is successful। क्या है भाई?
हम लोग को सरप्राइज है सो देखिए क्या किया गया। उसके बाद फिर गवाही के लिए रखा गया।
अच्छा, ऑर्डर 12 रूल 6 में फाइल हुआ जाएगा सीपीसी।
इसमें इसी स्टेज पर मैं हम लोग
ये तो डिस्पोजल हो जाना चाहिए इन टर्म्स ऑफ कॉम्प्रोमाइज।
बस इसी कम्युनाइज तो बात की बात है, जैसे डब्ल्यूएस फाइल हुआ था लॉर्डशिप उसी स्टेज पर जाना चाहिए था, एक नहीं मतलब इस पर दर्जनों जजमेंट है, अपने भी हाई कोर्ट का है और बाकी भी हाई कोर्ट का है।
ये आपके सारे जजमेंट्स हैं
ये हमसे कम्प्रोमाइज के ऊपर है और
अच्छा, और ये
कम्प्रोमाइज
जो
जो है मैंडेटरी है कि यदि ऐसा होता है तो आपको हर हाल में
जब ऑर्डर 12 रूल 6 में अगर कोई रिटन स्टेटमेंट फाइल होता है देन अंडर सच सर्कमस्टेंसेस द सूट हैज टू बी डिस्पोज्ड ऑफ
डिस्पोज ऑफ
इन टर्म्स ऑफ एडमिशन।
जी 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 ये भी है, इसके ऊपर जजमेंट है। हमने एडवर्स वेरिएशन पर भी जजमेंट आया था कि हम सीख कर सकते हैं, वो भी
हाँ वो तो आ ही गया, तो कोई बात ही नहीं है।
फिर उस बिंदु पर है हम एंटिसिपेट किए कि शायद क्वेश्चन उठे कि कंसेंटेड डिग्री है इस तरह का डिग्री है, तो उसके ऊपर बहुत स्पेसिफिक आया हुआ है ऑनरेबल एपिस्कोप का उसका यदि आपका प्रिंट में है वो चीज़ लिखा हुआ है तो कंसेंटेड डिग्री की रजिस्ट्रेशन भी जरूरी नहीं है। मतलब ऐसे दो पार्ट हैं, यदि किसी डिग्री से एक नया कोई टाइटल क्रिएट होता है तो उसका रजिस्ट्रेशन अंडर सेक्शन 17 रजिस्ट्रेशन एक्ट में कंपलसरी हो जाएगा। तो ऑर्डर पास होना चाहिए कि भाई उसको आप डिग्री तो दीजिए लेकिन रजिस्टर्ड करवा लीजिए। तो इसमें एथिक्स कोर्ट ने इसको क्लियर किया है कि यदि आपको सूट प्रॉपर्टी है तो वैसे में रजिस्ट्रेशन कंपलसरी नहीं है।
लेकिन रजिस्ट्रेशन होना चाहिए। हाउ विल थर्ड पार्टी हो? मान लीजिए कोई आपका एडवर्स पोजीशन डिक्लेयर हो जाए
जी।
और जो ओरिजिनल ओनर है फिर अपना टाइटल डीड दिखाते फिर से कहीं पर सेल करना चाहते हैं।
थर्ड पार्टी जो रहेंगे उसके ऊपर हमारे
नहीं ठीक है, बाइंडिंग नहीं रहेगी बट इट इज फॉर द नॉलेज ऑफ एवरीबॉडी। जब कोई डिग्री रजिस्टर होती है इट इज फॉर द नॉलेज ऑफ एवरीबॉडी। ऐसे तो क्या होता है कोई जजमेंट सिर्फ पढ़ा रह जाता है।
नहीं, इसमें इसी क्रक्स को
तो इसमें आपको क्या प्रॉब्लम है इसको रजिस्ट्रेशन कराने?
प्रॉब्लम ये है कि जैसे इसमें जो भी 1,51,000 रुपये हम लोगों ने दिया है 2005 में, तो आज का जो रेट होगा इसका और रजिस्ट्रेशन उस रेट पर होगा तो हम जी
ऐसा नहीं है ना। इस तरह से देखिए कोई स्पेसिफिक रिलीफ एक्ट में तो सूट फाइल नहीं होता।
नहीं
आपका पोजीशन आया प्राइमरीली आप एक तरह से पार्ट परफॉर्मेंस या इस तरह का कुछ भी आप लेना
तो
चाहते
उसमें ऐसा किया है, मैंने हम लोग समझा कि इसमें ही डायरेक्शन कर दिया जाए कि इसका रजिस्ट्रेशन उसी रेट पर हो जिस रेट पर 2005 में इसका जो ये तो स्पेशल परफॉर्मेंस का कॉन्ट्रैक्ट है नहीं,
जैसे ड्यूटी बनेगा उस हिसाब से होगा। हम लोग इस तरह का ऑर्डर क्यों करते हैं? इसका रजिस्ट्रेशन जरूरी है, नहीं तो फिर ना ये टाइटल लेके बहुत तरह के कॉम्प्लिकेशंस होते हैं। और खास तौर पे इस तरह के कॉम्प्रोमाइज डिग्री जहाँ होता है, एक तो इतना आसान नहीं होता कॉम्प्रोमाइज डिग्री करना। पता चले कि जो वेंडर है वो किसी और को बेच दिया और आपका एडवर्स पोजीशन यहाँ डिक्लेयर हो गया। समझ रहे हैं?
यहाँ पर पोजीशन डिफरेंट क्या है कि जो प्रॉपर्टी है वो हमारे कब्जे में है, वो फिजिकली कब्जे में, और ये इसमें एविडेंस में भी आ चुका है कि हम उसको मकान बना के रह रहे हैं और सारा कुछ जो रसीद वगैरह सब कुछ का मतलब जो
कौन है आप? है वेंडर?
हम
वेंडर है। आपने इसको कोई डीड नहीं एग्जीक्यूट किया किसी को इस प्रॉपर्टी से रिलेटेड? एफिडेविट ले सकते हैं।
इसमें किसी तरह कोई डॉक्यूमेंट दूसरा ये जरूरत है कि 2017 में मेरा टाइटल कंफर्म हो गया, तो अब जो भी डीड बनेगा मैंने रजिस्ट्रेशन में हम जाते हैं तो आपको नया टाइटल क्रिएट नहीं हो रहा है, नई स्थिति से नया टाइटल क्रिएट हो रहा है। तो लॉ बिल्कुल क्लियर है कि ये नया टाइटल क्रिएट नहीं होता है उस
एडवर्स पोजीशन जिस दिन डिक्लेयर होता है
जी
उस दिन डीड जाता है ना रजिस्ट्रेशन के
नहीं
लिए? एडवर्स पोजीशन का डीड नहीं जाता है।
नहीं जाता। जैसे कि जो दो प्रकार का डीड उसको जरूरत से बन सकता है। एक डीड बनेगा कि भाई इस तारीख को आज एडवर्स पोजीशन में आपका टाइटल हो गया, तो वो जो डीड बनेगा जिसमें इस बात को लिखा जाएगा वो डीड कंपलसरी रजिस्ट्रेबल हो गया क्योंकि उससे नया टाइटल क्रिएट हो रहा है। एक दूसरा डीड बनेगा जो मेमोरेंडम है, उसमें ये कहा जाएगा कि पिछले 2 महीना पहले आपका ये टाइटल बाय एडवर्स पोजीशन कंफर्म।
What was the terms of your settlement? कॉम्प्रोमाइज में क्या लिखे थे? जॉइंट कॉम्प्रोमाइज
उसमें सिंपल है कि हम आपके इस जो क्लेम है प्लेंटिफ का उसको ऐड करें। By the determinate difference of valuations of both parties to this suit, the dispute has only been set outside the court lawfully. The defendant does hereby admit and accept the entire claim of the plaintiff in total.
So therefore, since there was a joint compromise petition filed between both the parties, we decree it in terms of the joint compromise, and the joint compromise will form a part of it.
जी बस इतना ही की जरूरत है और कुछ की जरूरत नहीं। हम जो कोशिश कर रहे थे कि जो भी इसके संबंधित बाकी जो सिनेरियो हो सकता है वो सब मुझे सामने हम रख रहे थे। बाकी इसको तो कुछ करने की जरूरत ही नहीं, सिंपल डिग्री पास होगा ऑन द बेसिस ऑफ कंप्रोमाइज और डिग्री का पार्ट बनेगा, बस कुछ करने
बस बाकी जो होगा जो जानेगा जिसका जो होगा वो अपना जानेगा समझेगा हम एग्जीक्यूशन करेंगे।
ये वो इनके साथ अगर बाइंडिंग ही नहीं है ये उसके ऊपर वो तो इंडिपेंडेंट केस फाइल कर सकता है कि हम तो उसकी पार्टी ही नहीं। इसमें जो कंप्रोमाइज के ऊपर जो जजमेंट है ना कोर्ट का, मेरा थंबल सजेशन है कि उसको यदि कोर्ट कर देगा तो अपने हाई कोर्ट में बहुत अच्छा जजमेंट आ जाएगा ताकि लोअर कोर्ट में हम लोग आसानी से समझा लेंगे।
इसीलिए इतना सुन रहे हैं ना,
जी
क्योंकि आखिर आप इतना बोल रहे हैं कि इस तरह के बहुत सारे मैटर्स आ रहे हैं,
जी, जी।
तो एक कोई क्लियर गाइडलाइन हमारी तरफ से आना
जी
चाहिए,
बिल्कुल
unless that guideline is there.
जी।
और जॉइंट कॉम्प्रोमाइज आपका है डेटेड 38/2023।
जी
आप लेकिन इसको जो है ना हम डिक्री कर देते हैं इन टर्म्स ऑफ जॉइंट कॉम्प्रोमाइज, बट इट इज रिक्वायर्ड टू बी रजिस्टर्ड। इसको हम लोग ओपन नहीं छोड़ सकते। आप समझ नहीं रहे, इतना सारा लैंड को लेकर इश्यूज
उसमें ऐसा कर दिया जाए कि यदि कोई ऐसा संपत्ति जिसमें फर्स्ट टाइम जो कि है नहीं, अभी जो हमने दिया उसमें कि फर्स्ट टाइम टाइटल क्रिएशन होता है कंप्रोमाइज से, तो वैसी स्थिति में इसको रजिस्ट्रेशन हो सकता है।
हाँ, ये तो पहली बार ही होना ना।
नहीं, इसमें पहले वाली नहीं हो रहा।
इसमें तो बाय वे ऑफ एडवर्स पोजीशन तो पहली बार डिक्लेयर हो रहा है।
ये 2017 में हो गया,
कभी भी हो गया है, लेकिन ये तो डिक्री हो रहा है बाय वर्च्यू ऑफ कॉम्प्रोमाइज, और कॉम्प्रोमाइज आ रहा है 2023 में।
नहीं यहाँ पर क्रक्स ऑफ मैं बोन ऑफ कंटेंशन क्या हुआ 2023 में लाया था।
नहीं, देखिए, आई विल टेल यू वन थिंग।
जी
लेट अस थिंक ऑफ अ सिचुएशन where the defendant has already sold the property for somebody, right? And still the original deeds are lying with the defendant. He can still sell it to somebody. He can still sell it to somebody by saying कि मेरे पास original deed है, आप रजिस्ट्रेशन ऑफिस में जाके LSR करा लीजिए, आपको एक भी रजिस्टर्ड डीड नहीं मिलेगा, बेच देगा किसी को। क्या फिर फ्रॉड होगा, फिर सेटिंग असाइड से लीड होगा, यही सब। हम लोग को ज्यादा लिटिगेशन ये सब नहीं चाहिए ना, आप रजिस्ट्री करें। और अगर इस ऑर्डर ऑफ रजिस्ट्रेशन पर आपको कुछ है तो फिर आपको सुप्रीम कोर्ट से करना पड़ेगा, हम नहीं तैयार हैं इसमें।
ठीक है, हम गो डाउन। यहाँ पर एक बात है कि यहाँ पर की क्या इस पर्टिकुलर केस में क्या स्थिति है कि ओरिजिनल सेल डीड जो है वो 2005 में वो हमको दे चुके थे। यहाँ पर स्थिति ये है
एग्जिबिट कराया आपने ओरिजिनल सेल डीड?
जी एग्जिबिट कराया उसमें
ओरिजिनल सेल
जी ओरिजिनल सेल डीड वो सर्टिफाइड कॉपी देगी। तो जिस समय हमने उनको पैसा दिया था उस समय सारे सब कुछ सामान था हमारे उनके बीच में, तो सारा पैसा लेने के बाद उन्होंने हमको दे दिया। ओरिजिनल सेल डीड उनके पास नहीं है और ये ऑलरेडी एग्जिबिटेड है उसमें, भी ऐसा नहीं कि हमारे पास रखा हुआ है।
दूसरा एग्जिबिट नंबर क्या है ओरिजिनल सेल डीड का?
ये एग्जिबिट 2 है।
अच्छा, एक बात करते हैं
जी,
अगर आप बोलते हैं कि इस डिक्री से टाइटल आपको क्रिएट हो जाएगा ना, टाइटल क्रिएट हो जाएगा?
नहीं हो रहा। यहाँ पर बड़ा हम्बल सबमिशन है, इससे टाइटल डिक्लेयर होना आज के डेट पे नहीं हो रहा है। हम
नहीं,
सूट क्यों
डेट अपनी जगह है, इस डिक्री से आपका टाइटल क्रिएट हो जाएगा?
नहीं मेरा टाइटल का डिक्लेरेशन होगा, क्रिएट नहीं होगा। मेरा जो टाइटल पहले से एग्जिस्ट कर रहा है हम उसके डिक्लेरेशन के लिए आए। हम आज टाइटल लिया क्रिएशन के लिए नहीं आए उनके पास। हम आए हैं कि हमारा टाइटल 2017 में क्रिएट हो चुका था और उसके बाद हमको डिस्टर्ब करने के लिए 2023 में जब भी जो कॉल ऑफ एक्शन बना होगा उस समय डिस्टर्ब किए प्रतिवादी, इसलिए हम मुझे के सामने आए हैं।
तो फिर अगर मान लीजिए जस्ट
जी
इफ टू पार्टीज एग्री,
जी
भाई हम एक एग्रीमेंट ऑफ सेल कर लेते हैं।
हाँ ये
जस्ट अ मोमेंट,
जी
एक एग्रीमेंट ऑफ सेल कर लेते हैं और दूसरा बात हम एक एडवर्स पोजीशन का क्लेम कर लेते हैं।
जी
उसके बाद एक हम जॉइंट कॉम्प्रोमाइज फाइल कर देते हैं एग्रीमेंट ऑफ सेल एग्जीक्यूट होने का कोई सेल डीड एग्जीक्यूट होने का कोई जरूरत नहीं है, मेरा टाइटल तो क्लियर हो जाएगा और रजिस्ट्रेशन भी फीस नहीं देना पड़ेगा हमको,
जी
मेरा स्टैम्प ड्यूटी पूरा बच जाएगा।
बिल्कुल बिल्कुल सही बात।
ये एक डिवाइस नहीं है।
बिल्कुल बिल्कुल इसी के ऊपर हमने एग्रीमेंट को दिया ना, इसी पॉइंट को हम मुझे साहब ने खुद रेज कर रहे थे, मुझे के बोलने के पहले खुद रेज कर रहे थे कि इसमें एक फॉर्जरी की संभावना आ जाती है, क्योंकि बल्क ऑफ केस वाली सही केस है, लेकिन बाकी लोग तो इसका मिसयूज कर सकते हैं।
यस,
उसका क्या उपाय है?
उसका यही उपाय है कि रजिस्ट्रेशन करें।
नहीं उसी के उपाय के लिए लेजिस्लेचर ने सेक्शन 17 को अमेंड किया कि वहाँ दो प्रकार के चीजों को उन्होंने लाया। एक कि यदि तीन इनफैक्ट उसमें
लाइक रजिस्ट्रेशन सेक्शन 17 दीजिए रजिस्ट्रेशन।
सब सबसेक्शन 6 में जो मिलेगा
2 रोमन 6
ये सेक्शन 17 में।
हाँ
जी एनी डिक्री और ऑर्डर ऑफ ए कोर्ट एक्सेप्ट यही इसी को अमेंड किया गया except a decree or order expressed to be made on a compromise and comprising immovable property other than that which is the subject matter of the suit or proceeding। पहले क्या था कि हर वो डिग्री जिसमें कि हम लोग कंपनी फाइल होता था उसका रजिस्ट्रेशन हो जाता था, इसमें चेंज किया गया कि उस डिग्री का रजिस्ट्रेशन कंपल्सरी नहीं होगा जिसमें दो क्लॉज दिए गए, पहला कि कंप्रोमाइज में है, दूसरा कंप्रोमाइजिंग इमूवेबल प्रॉपर्टी।
नहीं पहले आप ऐसे नहीं पढ़िए
जी
नथिंग इन क्लॉज बी एंड सी ऑफ सबसेक्शन 1 अप्लाइज टू, ठीक है, पहले क्लॉज बी एंड सी पढ़िए, आप पूरा सेक्शन पढ़िए ना, सिर्फ एक क्लॉज नहीं, सेक्शन 17 पढ़िए।
जी सर हम सबसेक्शन 2 से शुरू करें।
नहीं सबसेक्शन 17 पूरा सबसेक्शन 1 से शुरू
ऐसे The following documents shall be registered. Is if the property to which they relate is situated in a district in which, and if they have been executed on or after the date on which Act 16 of 1864 or the Indian Registration Act 1866 of the Indian Registration Act 1871 or so and so of this act came or comes into force, namely instruments of gift of human property, other non-testamentary instrument which purport or operate to create, declare, assign, limit or extend use, whether in present or in future, any right, title or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable property. Second, non-testamentary instrument which acknowledge the receipt or payment of any consideration on account of the creation, declaration, assignment, limitation, or extinction of any such right, title, or interest, and lease of immovable property from year to year.
और ये 1 non-testamentary instrument transferring or assigning any decree or quote. So this is assignment. Then subsection 2.
Subsection 2. Nothing in clause B and C of section 1.
Nothing है ना? Nothing in clause this will apply to.
हाँ वो अप्लाई नहीं करेगा, ठीक है. Any composition date.
तो वो छोड़ दीजिए, आप सीधे 6 में आ जाइए.
जी. Any decree और order इस पर अप्लाई नहीं करेगा, लेकिन इसी में उसी कारण उसको ऐड किया गया था कि किसी भी डिग्री पर अप्लाई नहीं करता था पहले. अब अप्लाई करेगा किस पर? Except a decree or order expressed to be made on a compromise.
Nothing in clause B and C of subsection 1 applies. Exactly. It does not apply to a composition decree deed, right? It does not apply to a decree or order of a court. But it will apply to a decree or order expressed to be made on a compromise and compromising immovable property other than which is the subject matter of suit and proceedings.
That is the point. जो सब्जेक्ट मैटर सूट का नहीं रहेगा वो यदि कंप्रोमाइज में लाया गया है तब इसके ऊपर अप्लाई कर जाएगा, उसका रजिस्ट्रेशन कंपलसरी हो जाएगा. इसको जो हम कंपेटी नंबर 1 दिए साइटेशन का अनुरूप एपेक्स कोर्ट के उसको डिटेल इसका किया है.
कौन सा बताइए?
तो 3 दिए हैं उसके ऊपर मेरा साइटेशन कंपेटी नंबर 1 करके लिखा हुआ है.
समझ आ रहा है. जो 1, 2, 3 है.
हाँ उसको देखिए
साइटेशन से बताइए ना.
साइटेशन 2010 to 2001 वॉल्यूम 10 80 वाइसएफसी और 2020 AISC 796 जो पैराग्राफ 2 है मेरा पेज नंबर 2 पर.
ये कहाँ से आप डाउनलोड किए?
ये मेरा सॉफ्टवेयर है इसका.
इससे बहुत सारे AIR मतलब प्रिंटिंग से भी नहीं लग रहा है कि AIR का
नहीं इसको कंप्यूटर से प्रिंट आउट निकाला. इसको हम किताब के रूप में भी दे देंगे. इतनी बड़ी गलती नहीं कर सकते हुए कि कुछ चीज को चेंज करके हमने उसको क्रॉस चेक कर लिया है.
क्रॉस चेक तो करना पड़ेगा क्योंकि जिस तरह का प्रिंटिंग है उसको देख के नहीं लग रहा है कि कोई
अनि जर्नल से प्रिंटिंग नहीं है, मतलब फोटोकॉपी नहीं किया हुआ है.
जर्नल से नहीं है ना प्रिंटिंग?
नहीं जर्नल से नहीं है, इसको डाउनलोड करके प्रिंट निकाला होगा.
इस तरह से रिलायबिलिटी बहुत डाउटफुल हो जाती है ना. जब आप यहाँ पे कोर्ट में पेश करें तो ऐसा इस तरह से बहुत ज़्यादा मुश्किल है.
इसमें जैसे ये भी तुरंत मंगवा लेते हैं. जैसे इसका जो साइटेशन है ना,
ये जो तीनों है ना
जी
ये तीनों ये जितने भी आप कैसे ये सारे साइटेशंस इस तरह के साइटेशन को हम नहीं कंसीडर कर सकते. दिस इज नॉट प्रॉपर साइटेशन.
स्टिल दिस वन मेरे पास है. इसमें हम उसको फोटोकॉपी करके जो जर्नल से निकाल के दे देंगे.
ये जितने भी साइटेशंस हैं सबका ना हम लोग का जो प्रॉपर साइटेशन होता है उससे सबका ये आप क्यों दूसरे कोर्ट का क्यों ला रहे हैं जब सुप्रीम कोर्ट का डायरेक्ट जजमेंट्स है तो व्हाई डू यू नीड?
आई जस्ट लुक एट और
देखिए एक पॉइंट पे 4 जजमेंट की जरूरत नहीं होती, एक ही जजमेंट बहुत है. ठीक है और जितना पुराना जजमेंट है वो उतना ज्यादा अच्छा इसलिए है क्योंकि इट हैज टेस्टेड, इट हैज स्टूड द टेस्ट ऑफ टाइम. 1951 का जजमेंट अगर ओवररूल नहीं हुआ है तो हमको लगता है वो ज्यादा रिलायबल है क्योंकि उसको बार-बार कंसीडर करके उसको टेस्ट जजमेंट पास है अनलेस इट हैज बीन डिस्टिंग्विश्ड सब्सिक्वेंटली. तो एक पॉइंट के लिए ज्यादा जजमेंट्स की जरूरत नहीं होती.
इसमें अपने हाई कोर्ट का ही है 2022 का ही है लॉसूट का.
उसमें क्या हुआ है?
उसमें ही जो रजिस्ट्रेशन वाला जो रजिस्ट्रेशन का बात नहीं है.
हाँ
एक मिनट
लिखा है कि ये नहीं करना है रजिस्ट्री.
1227 है पेज 28 तक फिर उसको निकाल देंगे.
28 the legal position.
जी
आप पढ़िए तो सर.
The legal position clause 6 can on the basis of the pursuit discussion be summarized as below. Compromise degree is bona fide in the sense that the compromise is not a device to obviate payment of the stamp duty and frustrate the law relating to registration would not require registration. In a converse situation, it would require registration. If the compromise decree were to create for the first time right title or interest in immovable property of the value of 100 upwards in favor of any party to the suit, the decree or order would require registration. If the decree were not to attract any of the clause of subsection 1 of the section 17, as was the position in the Procedural Review Council and this court's case, the apparent the decree could not require registration. If the decree were not to embody the terms of compromise, as was the position in Lahore case, benefit for the terms of compromise cannot be derived, even if a suit were to be disposed of because of the compromise in question. If the property dealt with by the decree be not the subject matter of the suit or proceeding, clause 6 of subsection 2 could not operate because of the amendment of this clause by Act 21 of 1929, which had its origin in the proceed decision of the Privy Council, according to which the original clause could not have attracted even if it were to encompass property not litigated.
देखिए सारे बिना जजमेंट्स को डिसाइड पढ़े हम ये नहीं डिसाइड अभी करेंगे. आई रीड जजमेंट फुल टेक्स्ट, ठीक है, पूरा पढ़ लेते हैं. कल आप आइए कि अब तो कॉम्प्रोमाइज के टर्म्स में तो कोई डाउट नहीं, ठीक है. वेदर दिस इज रिक्वायर्ड टू बी रजिस्टर्ड और नॉट, वेदर एनी डायरेक्शन इज टू बी पास्ड फॉर दिस रजिस्ट्रेशन. नॉर्मली जब रजिस्ट्रेशन के लिए होता है कि कोर्ट का डायरेक्शन होता है कि क्या होता है?
नहीं, उसमें दो एस्पेक्ट उसमें भी है. यदि क्रिएशन हो गया उसमें तो डायरेक्शन नहीं भी होता है तो भी यदि वो रजिस्टर नहीं कराया तो ऑटोमेटिकली वो नॉट बाइंडिंग रहता है, जैसे कि जजमेंट में आ गया.
देखिए आपका जो केस है ना, आपका केस बहुत peculiar है. Where you say that there is an agreement of sale, you have paid the full consideration amount and you are in possession of the property. And at the same time you say, that you have the
hostile possession of that very property.
hostile possession. इस तरह का प्ली परमिसिबल है?
हाँ, जो भी एपिक्स कोर्ट का आपने लिया आ
नहीं, इस तरह का प्ली जब आपका कॉम्प्रोमाइज में तो हो गया है, ठीक है, लेकिन वर्चुअली व्हाट हैव यू डन? इंस्टेड ऑफ गेटिंग द डीड रजिस्टर्ड, राइट, आपने अपना कोर्ट फीस बचा लिया, स्टैम्प ड्यूटी बचा लिया और एक डिक्री करा लिया. इट्स अ डिवाइस.
यस, सिर्फ आई गो अराउंड
एग्रीमेंट ऑफ सेल होगा, उसके बाद कॉम्प्रोमाइज हो जाएगा. Now that will be decided in terms of the compromise.
तो उसमें execution of sale deed होगा by the registry office में होगा.
नहीं, by the registry office में तो execution of sale deed होगा.
जी.
ठीक है. But the point is कि अगर मान लीजिए कोई तो फिर बड़ा अच्छा है लोग अपना यही करें. क्या ही जरूरत है स्टैम्प ड्यूटी देने को?
बिल्कुल का यहाँ पे कंसर्न बिल्कुल जायज है, हम भी वहाँ पर सम्मत हैं, कोई हम भी नहीं चाहते कि ऐसा किया जाए, लेकिन ये स्पष्ट दिखेगा. जैसे कि अभी क्वेश्चन यहाँ पर खुद ऑनरेबल अपने हाई कोर्ट ने रेज किया कि यदि ऐसा डिवाइस है कि आप ओवररेट करें रजिस्ट्रेशन स्टैम्प ड्यूटी बचाने के लिए तो अप्लाई नहीं करेगा. हम भी सहमत हैं, यही चीज़ हम भी चाहते हैं, क्योंकि हम ऑन द पार्ट ऑफ हम जुडिशरी है. हम ये नहीं है कि किसी तरह कुछ ऐसा चीज़ चला है समाज में जो गलत है, लेकिन इसको दिखाने के लिए वो स्पष्ट हमारे प्लीडिंग से, मतलब जो केस हमारे आपके सामने है वहाँ ये झलकना चाहिए कि नहीं कोई फ्रॉड किया गया है. यहाँ पर जो हमारा केस है ये हम एक प्रकार को उस पर हम इम्पोज कर रहे हैं कि ऐसा हो सकता है, लेकिन हमारे बेसिक केस में इसको जरूर रखा जाए कि फ्रस्ट्रेशन यहाँ पर हो रहा हो, इस तरह की डिवाइस के जैसा इसका इस्तेमाल किया जा रहा हो, वहाँ बिल्कुल लागू नहीं है. लेकिन जहाँ पर ऐसा नहीं है, जेन्युइन जहाँ पर मामला है, वहाँ पर तो यहाँ पर तो फिर वो जो जेन्युइन लिटिगेंट है उनके भी राइट टाइटल और इंटरेस्ट के ऊपर प्रभावित हो जाएगा. इससे हम जेन्युइनली हम एडवर्स पोजीशन में हैं. तो ऐसी स्थिति में यदि राइट टाइटल इंटरेस्ट प्रभावित होता है और मेरा ऑलरेडी हो चुका होता है और फिर हमको दोबारा मैंने स्टैम्प ड्यूटी भी देना पड़ता है तो हमको परेशानी है. तो बैलेंस लेके लॉर्डशिप चलना होगा कि गलत व्यक्ति को प्रश्रय भी नहीं मिले और सही व्यक्ति को न्याय भी मिले. ये हम लोग देखना.
See, earlier at the position of law earlier was that this adverse position cannot be used as a sword, it can be used only as a sheet.
Yes.
Right? That was the earlier position of law. But now the position is that it can also be used for the declaration of right, title and interest with respect to the suit property. So by virtue of a decree, the title over the property stands transferred to the plaintiff by way of adverse possession. Correct? So whether such kind of decree are registered, they go for registration.
Registrable or compulsory registrable or not?
Yes.
This is the only question.
Yes.
My humble submission is that the moment that 12 years drifted away, on that very moment, my title is conferred under law of prescription, the settled position of law. At present, there is no creation of new title. At the time of institution of that very suit, there is no creation of new title. Because I was being claimed or I was being disturbed by the defendant, so only I came before the court and seek declaration, please let me a decree of declaration of title, not confirmation of title, not creation of title. This scenario may or not say. Decree is only that my title is being declared since the date of 2017, not from the date of decree. Under such circumstances, when the decree is not for creation of new title, rather for declaration
So
that
in this
earlier title
particular
was
case, your adverse possession will be declared from the date of compromise, or it will be from the date of passing of 12 years.
from the date of passing of 12 years.
No, because it is being decreed in terms of compromise.
You also
There is no adjudication. There is no adjudication at all. So your right is
in that
declared.
case also, Your Lordship, in
Yes.
that case also, Your Lordship, there is no need of restriction. When the decree is being passed on the basis of compromise and nothing is being done, just a compromise petition is being tagged with the decree only, there is no need to registration at all. If there is any creation of title in that very decree, then only the question of registration of that very thing arose. Otherwise, there is no need to even arise this very question whether this decree is registrable compulsorily or not. Here is the position that there is no need to pass even a judgment on any because
Any
compromise.
issue.
Yeah.
Compromise, even no issue is to be framed.
Yeah, no issue.
Nothing. It has to be
Nothing
simply
is
decided in terms of compromise.
compromise. Nothing is needed to be done. Yeah. If there had been any contest in between plaintiff and defendant, there would have been need to address this very question of compulsory registration or not. Just I have put all the things before Your Lordship. To be fair, this is the situation. Because this question was not raised by Your Lordship. I had just raised this question. Successors also there, registration is not compulsory. And this case is very genuine. Though there is nothing fraud is there. But someone can use this very device for evading stamp duty. I can say. So there must be balance between the wrongdoers, so that wrongdoers could not get benefit from that very provision, and for also the genuine litigant who are seeking justice from the honorable court.
सेकेंड हाफ में आप आएंगे? आपको सेकेंड हाफ में फिक्स किए? नहीं किए ना? इसको लिखाएंगे सेकेंड हाफ, ठीक है? ये सारे जजमेंट्स हैं ना, उनको बोलिए सब हमको चाहिए। ये सबका प्रिंट निकाल दीजिए। भेज दीजिए। आपको कोई ऑब्जेक्शन नहीं है? You have taken proper instructions?
Yes, sir, I taken that.
It can be decreed in terms of the compromise.
Yes, sir.
कौन सा वो ऑर्डर बताएं जिसमें it has to be decreed? Order number?
Order 23, Rule 1 and 2. Compromise decree क्या था?
Order 23.
Rule
Withdrawal and adjustment of suit.
जी order 23 compromise of the suit.
Order 23 is withdrawal and adjustment of suit.
Sorry, rule 3.
Compromise of the suit.